Item 1, somebody is missing. We'll pass over then. What can be done? We can't dismiss it.
Item 2. Your Lordship, the National Commission has overturned the concurrent findings of the State Commission as well as the District Commission.
You have to follow the decision of this court in that universal sampo.
Your Lordship, the fundamental
You'll
issue.
have to follow that.
Your Lordship, the fundamental issue is this.
No, we are telling you about the jurisdiction point.
Okay.
Universal sampo, you've seen it.
No, Your Lordship, the argument is
Same order.
fundamentally different. Your Lordship, the argument is fundamentally different here.
What argument? That's
Your
about
Lordship, the argument
jurisdiction.
is that the State Commission fundamentally decided upon deficiency of service was the fundamental rationale.
Have you
for this.
seen that
will have to-
decision? Have you seen that decision?
Universal Sompo, you will have to challenge this order before the High Court.
Anyway, same order. We'll get it. Next.
Item 3.
Same order.
My lords, we have moved an adjournment letter. My lords, there is some medical emergency in Arguing Council's house. My lords, may I adjourn it?
Okay, three letter.
All right, as per the letter.
Please. Please.
ये first adjournment है.
4 minutes, Trivedi is there.
My lords, these are same matters your lordships have earlier passed, granted leave by order dated
Yes.
12th of
You're
August
right.
24.
Same order.
And state contempt by a subsequent order, my lord. The contempt proceedings were stayed.
Yes, same order. Stay of contempt. It is
There's a
enough.
delay, my lords, I think. There's a delay, my lords, I think.
Notice now.
Delay may be condoned, my lords.
My lords, that's along with 4 and 57, my lords. Item number 4 and 57.
4 and 57 both.
Grateful.
Item 5.
105.
My lord, my argument is completely different in this. This is a young boy of 19 years,
Boy.
19 years, who in 2014 wanted to do
5, na?
wanted to do business. So he had 3 businesses: educational advisory, digital advisory, and investment advisory. He didn't know that 1 year back, a regulation has come where he has to get registered. 6 years later, when he was 26 years old,
Just asked him to be repeated.
no, I'm only on a small little point that out of that 1 crore 25 lakhs which he collected in his account in 6 years, only 13 lakhs is from investment advisory. And that is the only refund that I'm supposed to make. And this is what I wanted to tell SAT.
No, but then you are saying that 1.25 is not from outsiders, is that?
No, it's from
Debate?
outside. It's from outsiders.
Then?
So my problem is, it was ex parte before SEBI. When I went before SAT, I was 4-5 years late. So they didn't hear me on merits. So I'm only wanting to point out to SAT, if my God gives me that permission, that what the computation is wrong. That's all.
File and petition there.
But my lord, because they have dismissed it on the delay. My problem is that what do I do after, and this was a young man, my lord, in a small town who was doing business on his.
All right, you'll see. Notice.
Just send us back for computation.
We'll see when they come back, we'll see.
Very well, sir. And on the first hearing, SAT also wanted to do that.
That's the.
But then on the day of final hearing, it decided on merits and dismissed my case on delay, my lord.
We'll see.
Grateful.
Item 6.
In Raymond Woolen Mills, my lords have said, my lords, only a prima facie view is required, my lords, at the stage of my lords issuing a 148. And what was, my lords, looked at by the assessing officer was, my lords, the my lords, arm's length price, and it was referred to a TPO. My lords, here the issue is, my lords, whether, my lords, this reversal could have been done and where the effect would be. Whether, my lords, this is... Malas, where the effect would be. Malas, we have in the grounds, Malas, given an answer to each of the Malas, reasoning that has been given by the High Court, Malas. High Court is, Malas, totally incorrect to say, Malas, that this is, Malas, no material. Malas, that no material was brought in.
15 assessment, Mr.
Malas, that's what we are saying, Malas. This effect could not have been, Malas. It's bad debts is only in the year where it has been reversed, Malas.
No.
Therefore, Malas, this has to be gone into, Malas.
Not necessary.
Malas,
We'll leave it. Dismissed.
deeply obliged, Malas.
Identical matter notice has been issued on 13th February.
Limited reopening of writ petition. Similar matter.
Similar matter, same parties. It was just a second petition. This is what listed.
All right, notice.
Small delay in refiling.
Notice and post along with that. Huh?
What is a small delay in?
Yes,
I think it's reopening. No, we thought there's no restriction to that.
yes.
Notice, same order.
Public.
Suppression.
Lordship, item 8, may I request Lordship for the password?
There's hardly a suppression. We'll issue notice. Hardly a suppression.
Grateful, Lordship.
May it please your lordships, Malats, in this matter, Malats, what is an issue is, Malats, the home.
Two separate entries, no?
Please, Malats.
Instruments or apparatus for
Please,
chemical
Malats.
analysis and
Please, Malats.
instruments and appliances for medical.
This is, Malats, used
What
by,
more do you say about the delay?
Malats, it's used by people at home, Malats. This is something very different from what is used in laboratories, Malats. Therefore,
901.
Malats, may kindly have, Malats, page 57, Malats. Only I will show one paragraph, Malats, and place it, Malats.
Department of
It's all concurrent only.
Dismiss.
Dismiss, dismiss.
There's another matter dismiss. What they're relying on.
Dismiss, dismiss.
Deeply obliged.
Delay condoned, shall be dismissed.
Item 10.
Electronics.
I succeeded, my lord, in first appeal.
Eventually it goes round.
My lord, with great respect, I am not an importer. I am not the importer, my lord. Importer is somebody else. I pay royalty. I made a charge for your lordship's consideration. Can I just show it, my lord? This will, my lord, lead to chaos. Just
Both
have-
payments must be subject to customs.
What is
If
subject
there's
to
anything
customs
wrong.
is import, my lord. I am not the importing party. Just have a look at this.
But I think it's all interconnected.
This will, yeah.
Stake.
My lord, your lordship will
I-
find, your lordship find, my lord, on the right
It's not very.
is Xiaomi China.
Huh?
It's a case of
Similar matters pending, connected matters.
By another.
No,
They can't be duty on contract
Act with
manufacturing.
Civil Appeal 876.
That's the penalty part, which is
No, that
Penalty
is-
part.
yes, our worker, which is there,
Arising out of the same order. right?
arising out of the same order.
So similar matters, my lord, will follow.
Yes.
Because of this judgment, every manufacturer of telephones will have to do this.
Every contract manufacturer will be affected.
But then, there is an issue. Anyway, you take notice, we'll hear them.
My lord, I will explain to him, my lord, it is absolutely absurd what is happening.
They issue
The,
notice.
the appellate court, normally, my lord, the first appellate court is the commissioner. He holds against us. It's a reverse. Here it is the reverse.
You'll issue notice.
It succeeded in first appeal. It is reversed, my lord, by the authority, by the judge.
That's exact.
That there is no sale.
Yes.
I am the
There's no transaction.
And
Issue notice, issue notice.
I just can add, well, just my lord said that both the transactions should suffer tax. As a matter of fact, both have suffered. I paid
Both have, that's-
GST in India more.
I have paid GST also, my lord, and royalty
So,
also.
either you
That
can't
man
take-
has paid custom also.
You can't take both.
How many duties can go on?
It's rounding.
So the-
Xiom
you can-
China and Xiom India, between them, will
No,
have.
no, we take for a minute, let's take adverse for a minute. Either you include in the custom
We will
valuation.
take who is the, it will be the principal of commissioner.
Yes.
Yes.
Let notice be a copy. You take. Oh, you're there already. Yes.
So you see, ultimately, the money is there with the department. You take in a GST pocket or the custom pocket, that's the only issue. Transaction is not the,
You're right. Yeah.
because
Mr.
No, we are paying for-
Additional Solicitor General.
We have paid, my lord, 50 odd crores. Let that be worked out.
Accept, someone in the central agency give the name, accept
Yeah.
notice on behalf.
After 2 weeks, my lord, your lordship may work out what interim position.
We will seek.
Mr. Makkar is.
You take instructions, we will
We serve it to Makkad.
file it. File a short counter to explaining what it is.
Lord, I may be permitted to file intervening application. I am also another contract manufacturer.
Okay, Mr. Venkatraman? That intervener, we don't know who he is.
I'm the
appearing.
caveator. I am also one of the contract manufacturers.
Okay. You're there, post along with that. Your
Sorry.
side will also be
Caveator.
taken.
One more.
Everybody-
We said more the merrier.
well, every contract manufacturer in this fashion will come into this thing. That's the how.
It has very serious consequences. Yes.
Give rise to more litigation, yes.
My lords, I was the original defendant and only in execution
How many times?
I came to know that the land is 4R. My lords, I am for the petitioner, original defendant.
Consent decree has become final. How many times how many attempts you will make?
My lords, I have already paid 23
Attempt
lakhs
through the
after the High
execution
Court.
application, the writ petition, IA,
My lords, kindly bear
every
me for 1
form that
minute.
has been upheld.
My lords, for 1 minute only. My lords, I was paying the amount and 23 lakhs till today has been paid out of 28 lakhs. Only in 2024 during the execution petition, kindly see page number 70 to 72. My lords, when they filed the
Will
mutation,
not permit you to drag it anymore further. And
my lords,
in any
only
event,
5
there is a
lakh issue is there. My
330
lords.
days delay for you.
My lords, I
So
have the
many
answer.
attempts being made. Huh? It's a
My lords,
complete afterthought.
only 2 attempts, my lords, because only after 2024 I got
Thank
to know
you.
that I have
Dismiss
got 4R land, my lords.
Dismissed.
My
Next.
lords, only one indulgence, my lords, only one indulgence. My lords, kindly see page number
You
72.
want us to condone the delay or not necessary?
Yes, my lords, I want to condone the delay, my lords.
Personal
Just,
delay. From your side, okay. Delay condoned, SLP dismissed.
my lords, kindly see page 72, my
Oh,
lords.
yeah, no, not this case. Next.
Grateful, Lord. Similar matter is pending, Lord. Stay also.
In one case, we dismissed it.
Lord, whole batch is pending. My lords may call it in one day. We'll assist the court and let the final order be. Whole batch
All
is
of them.
pending. All of
Put
them.
all of them
We'll give the
together.
numbers tomorrow to the court.
Give the numbers.
We'll give it.
Because I think this is generating more litigation
No,
in the High Court.
March, my lord, whenever it's convenient. It's a short legal point. 56 and 72 also. Same. 56 and same. Baggage rules.
Baggage. The supplementary list. We point out with the numbers.
72.
Give the list. We'll list it.
Item 13. Maybe dismissed on delay, my lord.
Yes, delay. Dismissed on delay. Yeah, 14.
Yes, my lords. Now, my lords, kindly have a look at my lords, page 1.
Voluntary. You make a
But kindly see 163, my lords, the report of the auditor is qualifying report, my lords. The report of the auditor in term states, in absence of complete documentation, 163, also may just have one line, my lords.
But anyway, it's not as if
My lords, kindly have a look at this fact,
unilaterally.
600 rupees was given through the LC. 1,600 rupees given by the company to Magnum, out of which 1,300 through the LC. Your lordships are aware, LCs are open through the banks. The bank would verify documents only after the amounts are released. 16 banks involved in the process, they release 1,300, out of which 1,454 comes back in the company, admitted.
Managing that, you to say that you are unaware of it. Are you appearing in this, Mr. Venkatraman?
I am appearing with the caveat, my lords.
To say that you are unaware.
No, my lords, I'm aware. I'm saying I'm aware, but kindly consider out of 1,600, 1,454 money comes back in the company bank through the bank.
When you
200 crores is outstanding, for which, my lords, I've disclosed in the balance sheet. My lord, there is something known as recovery.
when you do this kind of by way
It
of
was 90%.
voluntary winding up.
No, my lord, this
No, IBC section 10.
Your lordships are right.
Commences under section 10.
Lordships
not
are right, but
ordinary matter.
went through the process of CIRP. My lords. This is liquidation proceeding. Kindly consider.
How did it commence?
Your lordships are right. My lords, 10, of course, my lords, ultimately, please consider, out of 100 rupees, 90 has come back in the books of the company, admittedly, through the banks. 10 rupees remain outstanding, which I have accounted for, made a provision in the books, my lords. Because I can understand nothing comes back in the company.
If it were in the ordinary courts, we would have accepted
Lords,
it. 1 minute.
I'm sorry.
We would have in the normal courts accepted. Prior to a decision that the NCLT has taken,
Yes,
or even the RP or the liquidator has
My
taken,
lords, my lord.
is asked for a forensic audit.
Yes, my
And
lord.
forensic audit report came, and it is on that basis that we're saying it.
The report, when
unaware
I
of-
read the report, I'm trying to report only. Report says, just one line for my lord's kind consideration. Report says, in absence of complete documentation by the report, he says, being available as supporting documents and these transactions, we could not conclude on whether the transactions were utilized for diversion, stroke, siphoning of the fund. This is the report of the forensic auditor, based on which I'm held guilty, where out of 100 rupees, 90 has come back in the company.
What do you say about this part of the report of the forensic report? What do you say?
My lords, the supporting documents were missing from the company's records. In fact, this question was put to them before the NCLT, before the Honorable NCLAT. Even at that stage,
For
no
this
justification.
particular finding, what do you say?
Look, this finding, the forensic audit report was prepared on the available sample documents that were there.
Over and above that finding, how did NCLT get over that to compare?
Because a bare perusal of the books, my lords, it shows that the total purchases out of the 1600 crores was just merely 6.5 crores. And then it was put to them, you explained to us what was the transaction. They could not explain at both the occasions. It's concurrent finding of fact, my lord.
That's what he's arguing.
Concurrent finding of fact.
Prove against
Commercial
you.
transactions, my
Because
lords
it's
are
a
aware.
preponderance of probability. You are arguing as if it's a criminal case. You are in charge of the company and you are the person in the complete control of everything. To say that you must prove means you would have your own ways of dealing with it, which people will not know the way you have dealt with the transaction. So therefore, it speaks for itself.
Feroz, can I?
If there is a suspicious transaction, you must take the responsibility.
Feroz, can I urge with respect?
And you can't say that it's a suspicious transaction, but where have you proved that it is because of
That's
me?
what-
You are in domain control.
Feroz, can I request? 4 years before, the company goes to the RP and the liquidator. I'm out since 4 years. They conduct a forensic.
Your own making, sir.
Feroz, but kindly.
You have filed
but,
section 10.
Your Lordship, sir, I bowed down, but kindly have a look at this fact. On this transaction in
Not
particular, Feroz, kindly have a look at this fact. A pure transaction through the banks. Letter of credits opened by 6 banks, nationalized banks. Money is sent through the bank under the LC. Feroz, I can
Don't ask
understand.
us to. Don't ask anybody else to explain. You should explain.
Feroz, can I say, Feroz?
He should explain.
I am wanting to explain, and I explained this by saying, out of 100 rupees spent by the company, from the company goes to person A through the banks. Whereas from 100 rupees, 90 has come back. 90 has come back in the books of the company. 10 rupees remain in respect of which, as per accounting standards,
Anyways.
I made provision. Now, how do you allege fraud, my lord? With all respect, I
Sorry.
can understand.
We'll leave it at that.
66.
Thank you. Thank you. We'll leave it,
Sections-
we'll leave it at that. Thank you. Dismissed.
Please, your lord, please. I'm grateful.
Yes.
Lordship.
Similar matter, non-est filing. We'll post, this has to be heard.
That's right, my lord.
Not a big issue, actually.
Actually, it's a small issue, my lord, but
It's
other
actually a
matters
small
are-
issue.
Yes. Other matters are.
No, it's small issue, but it affects them.
But
It
the
affects
difficulty-
anybody for that matter.
difficulty in this matter is that the
Anybody
award
who
itself
wants to
wasn't-
challenge an award, in some judgment, we said that scope itself is so limited and we make the procedure so strict. So you lose out because awards are all types of awards.
There is something in
Only
this matter.
scope under 34 is you take away by non-est filing. Multiple, it's actually a culture of practice, which we have written recently. Because we do it, because limitation is coming, you just file it and keep quiet, because that's how we all operate to get over the limitation. But our litigation experience is percolated even for arbitration. Will you say the same thing about non-est filing for a regular first appeal?
No, that's not the requirement under
No?
CPC. That's why, because over here, what has happened is
No, any statute, will you say that?
award not
But it's the
filed.
practice. Once a filing is done, it's a filing is done.
Award not
But
filed.
unless court finds that you're deliberately, that's a
That's
different.
right. So
That's
the
a
court
different
finds
issue.
that there is a deliberate attempt.
To post along with that.
Very
We'll, अरे इसको, just give us a list of those connected.
No, we'll give those.
There is already a date. Date.
There's already a date.
Yes, there's already a date in March.
You just take half an hour, we'll find it.
Right. Great.
17.
Made this means.
Right.
Two issues in this matter.
Good, no? We'll issue notice. Association should be permitted to file. It's a person.
Person, that's and three
Notice,
things
notice.
against which your lordship have dismissed also SLP. That
Sorry?
one SLP, my lord, by the association. The order which was.
Oh, you are for the state.
I'm for the state.
Okay, we are saying that the association should be permitted to file.
Be permitted, your lordship.
We don't agree. We don't agree.
Well, so lordship can see that.
You should reduce litigation, mister. What? How are you bothered anyway?
I'm the state, my lord.
If it is a common question, if there is no overlap of cause of action,
Judgment. The problem is, my lord, there are two findings in the tribunal. Kindly see, my lords. Page 109.
This is again 316 which I have attached page.
This also questions that
Association, one of the, not this.
association should not file, is it?
Association in a transfer matter, let the agreed parties file, you need not file. That's what the finding of the tribunal, High Court, and SLP filed by the association dismissed. That is one of the point, but I'm not saying that is the only.
No, this challenge here was with regard to transfer norms, not individual grievance.
Yes, correct, Malad, that's what I'm saying.
So what's
Therefore,
wrong?
an association can always.
Fine, that's why I'm just kindly see page 109.
That will be.
I just want to test that.
Right.
Yeah, page.
So it all depends on case to case.
Correct.
If they espouse a common grievance, quote unquote, a common grievance, why should 150 people file original application?
Kindly see, that's why I'm taking you up to tribunal's order. What the High Court looks into the one point. Kindly see page 122. There are 2 points considered in this, paragraph 2 and paragraph 3. High Court goes on the footing only on the locus of the association. Kindly see paragraph 2. In effect, it says, I don't want to interfere in the on merits of the matter. Also, paragraph 2, it says, my lord, on the norms. We don't want to interfere because what is challenged here is the norms set for IUs, entire all 6 departments.
Then why should everybody file?
That that now, my lord, only Ayurvedic department challenging by saying that you carve out us separately and give a separate norms for that. That High Court says, my lord, that's a tribunal says it's a norms fixed for everybody, then you can't individually do it. So that
Distinction court can always draw.
That's why, my lord,
Saying there are 2 categories in this, it can draw the
so
distinction.
it's not, my lord, IUS is for all the departments of Indian medical institution. But what is challenged is only Ayurvedic. That's why, my lord, we are before
What is your grievance? What's your problem?
I must state, my lord.
We're asking you, what's your problem?
Well, it's challenging by norms, which is implementing the transfer not having given effect to because of the way saying that well, there are 2 norms.
We are only on a small other issue as to whether an association can maintain or not. We are on that question.
Well, that's a larger issue on
That's the
section
question.
19, well, that's in Tribunals Act, well, section 8. We are not on 226 Judics Act.
But then the merits is open. The case has not been closed.
No, that's why I'm saying that it's a tribunal. Well, it's in the act. If every norm is challenged by the association, when there will be a different of people who are accepting it, not accepting. That's why you're not just putting a locus always in the service matter. There's no public interest litigation. 3,000 strong millets. So when anybody is aggrieved of particular transfer in the norm, they can challenge independently.
So they can't challenge the norm itself.
Yes, norm independently they can challenge.
Why?
But coming to the association, there will be always difference of opinion with the association. Some people may agree, some people may not agree.
It's on a case-to-case basis.
Well, case basis, what you want to do in association along with the
Then your distinction is wrong. If an individual can challenge it, and there is a bar of association to challenge, there must be some point of distinction.
That's why I'm not.
So if an individual can challenge the norms as well as its application, association also can do it. So far in its application, the court will draw a distinction.
Look, sir, there is one more thing. In the earlier judgment, which 3 and 6 I am pointing at, my lord, there is a finding by saying that there was an amendment sought in Kerala Administrative Tribunal Procedure Rules and representative capacity, whether they can file it or not. That amendment still today
This is still pending, no?
has not been done. So let's consider that in the absence of the amendment, in the absence of the amendment, in the absence of the amendment, my
All
lord.
questions are open for you to argue.
You have to defend your decision on merits, like nothing. I mean, it has been remitted to the tribunal.
So therefore, you should have confined your argument.
So
Well, this will confer a right, Mother. That's why I wanted to place the 2-3 judgment. So let's have it next week. I will place it because
A person, huh?
yes, I will place all the judgment because there is no pending rule. The amendment rule was suggested to amend, my lord, in the Kerala Administrative Tribunal Procedure Rule to give a representative capacity so that association can file. That rule, according to the High Court judgment, my lord, in another case where it
Changed the question before the High Court, which it remanded it back, was only question as to whether an association can maintain an original application. They interpreted 19 and said that there's nothing wrong in association, go back and argue on the merits of the matter. Today, it's only on merits of the matter.
There's 2 points which I'm saying the norms cannot be challenged. That's what also says, my lord, the association, because the transfer norms, my lord.
Then that's a preliminary question you will raise and argue.
But that's given a finding in a tribunal in the point
What shows the tribunal?
Point two in paragraph 122.
What is that?
Relying upon the other judgment, it says.
Page 1.
Page 122, my lords, it's a tribe against which the High Court order, it's the impugned order.
Which annexure?
Shows the impugned order.
This is a 122, this is the order.
Annexure.
You are showing the tribunal's judgment.
I'm sorry, one second. So I'm giving annexure number. Annexure P5 starts with 109. I'm sorry. That's why.
Jayan,
109. I'm sorry. It starts with 109.
that is a tribunal's judgment, right?
Tribunal against which the High Court was first the impugned judgment. Kindly see paragraph 2.
High Court didn't set aside. High Court did what? Just read the High Court judgment.
Let's High Court says it's only on locus. Finally, see paragraph 2.
See.
That is also on merits. Paragraph 2 is the norms fixed by the department cannot be challenged in the tribunals before the tribunals. Because that is maybe under 226 jurisdiction if it is arbitrary or it's a discriminatory. But not under the administrative tribunal jurisdiction, that is a paragraph 2 which they wanted to declare by the tribunal itself in this matter by saying that I am not going to read because
Show what?
does not have
page you want to show?
intermediate.
Shows which page? 120?
122 paragraph 2.
Wait a minute, let me just.
Operation in accordance with law, that's the direction. All contentions are kept open. High Court has directed the tribunal to consider the matter afresh in accordance with law.
This finding
I
already
mean,
I have, my lords.
it's very difficult to countenance this argument that norms framed by you can't be challenged by anybody.
No, it challenge.
Are they so sacrosanct?
Much-
And how does it matter to you whether an individual employee challenges or an association?
The distinction between.
Jurisdiction point, my lords, not the rights.
Okay, listen to us. So far as the tribunals are concerned, number of time we have held that they are worthy successors. They replace 226. It's a constitutional tribunal. It is not a statutory tribunal. Your argument the tribunal can't look into the validity of that norm is completely wrong. They will be entitled to. It's a constitutional tribunal. What are you saying?
Both the points, lords.
Then you tried enough.
But judgment, my lords, I
Raise all this. Don't put people to trouble as it is. Your state is dismissed.
very difficult. Some group of
Dismissed.
come, my lords, then it's
All right. Dismissed. 17. 18. The constitutional tribunal.
Permitting us to proceed with the.
Same order.
Same, my lord, again.
Same order, sir.
Delay may be condoned.
You have added something for you in that.
Yes, my lord.
You did you read properly? Answer from that the respondent has in fact challenged the said notice by filing a writ petition under 226. And needless to say that the petitioner will be entitled to raise all objections, including questions of law and fact. In opposition, it is for the High Court to consider and dispose of all facts and.
Let me try my.
You're right. Good luck.
Great.
But you are right. That's it. You were rather reluctant to dismiss it.
Lordship, Your Lordship, in this case, the Honorable High Court has directed the NMC to accept the physical copy of the application along with the physical payments through demand draft. As my lords, the regulations and the invitation for inviting the applications were very clear that only online applications will be entertained in this. Now, the Honorable High Court has.
We will say that this is not a precedent. You will be satisfied, right? We will do that, okay? While we are not inclined to interfere with the order passed by the High Court directing handing over physical copy of the original application, we clarify that such a direction should be treated as an only in the facts and circumstances of the case. The order, we also make it clear that the order shall not be a precedent. Shall not be treated as a precedent. Order passed by them, but shall not be treated.
Right.
Please, your lordship, I am being led by the learned AG in this matter. He is not available.
Item
today.
20?
Yes.
Letter it seems. 21.
20.
20. ये कौन सा होता है? No, ये कौन सा item? 21, हाँ.
Not 21.
Little doubt in this.
21, my lord. Yes, my lord. Lord, this is purely a misinterpretation of the notification, my lord. So grateful, my lord. My lord,
Let them
stay of the assessment.
That's the in addition.
My lord, there is a delay of 116 days.
That's why take notice.
Okay.
Let them come, we will grant you.
Lord, in the meantime, no coercive steps be taken. That's all.
Come back in 2 weeks. We don't really know. But
Very well. Very well. I'm so grateful.
22, my lord, my difficulty is that the High Court has only partially read the settlement. It is right in saying that 3G says that if you receive after 3 years, you will get something.
they have
But
not
there's a
yet
second
received.
part.
No money is yet received.
No, now they have actually received. I placed that in the
Then
additional
you should
document.
go back then enforce it.
But I'll tell your lordship what I'm requesting. All contentions have to be left open. Why?
It's not
Because
left open here.
no.
All that the High Court said. Anyway, you argue.
Yeah,
all that the High
I'll
Court
just
said.
explain why I'm asking for that. 3G is in two parts. You receive money from those two proceedings, you will give me pari passu. Second part is I am also entitled to compensation and losses. That has to come from any other source. The way the High Court order.
Para 9, your question is answered.
Yes, Manoj, I follow that. Para 9 at page
Just
5,
that,
when they receive, but it should not be interpreted that.
However, as and when amount is received under clause 3G of the judgment data within 15 days of it shall inform the decree holder.
No, the
decree shall be at liberty to file afresh.
Candidly, I'm saying they have done that. All I'm asking is that if I go back again, the High Court should consider the settlement in its entirety and not limited only to the part that they have received money, so you will get out of that. There is a second part to this. There was an earlier order of the High Court asking them to explain that aspect of any other source. Please just see that order. All I'm asking is leave all contentions
Advance
open.
ruling, this is called.
No, just leave all contentions
Assuming
open.
for a minute they don't follow this direction, you will anyway come in appeal saying that.
But my lord, that will be again further.
That's why we are calling it as an advance. Should be done. Thank you. Dismissed.
Very well. Good.
May it please, my lords. My lords, I had all the permissions. The only thing they decided against me was, while rejecting my application, is that it is 200 meters from the industrial area. Please have a look at page 87, my lords. And my lords may just note at page 86, this is survey number 384. Area is 5.5 foot. And this is 200 meters. If it is 200 meters from industrial area, how can the others be given? And I have all the permissions, my lords. And today my appeal is pending from August 25, my lords.
What happened to the 30th October 25 letter? Which
3rd October.
In favor of R5? Did you
So he has started mining. I'm sorry.
Did you challenge it?
I'm sorry, my lords.
Did you challenge that order?
My lords, in my writ petition.
You didn't challenge that order.
Yes. My prayer before
what is High Court is saying,
yes,
that's only a letter given to Naib Tahsildar. And in the meanwhile, R5 has got a contract and you have not challenged.
No, my lords, please see page 134. I have challenged page 133. This is my writ petition prayer. At the bottom, my lords have it. 133 at the bottom. That's my prayer. To quash, set aside the impugn order 310, which my lords is referring to, passed by respondent to, and the application filed by the petitioner for grant of query, so and so, and the respondent be directed not to create any third party rights. Today, my lords, my respectful submission before my lords.
8 and 25. Which page were you showing, Rahul?
Yes. So my first submission is, my lords. Please have a look at page 87. The reason which they reject, my lords.
87.
87. This is dated 25/7/25. My lords have that? For the disposal of.
What is it?
Appeal is still pending, my lords. And today my difficulty is what I am respectful.
What's the problem?
No, my lords, what I respectfully submitting for this same area, they have given it to someone. And the reason they reject my application is that this is 200 meters from the industrial area. If it is 200, it is for the other side also.
By which order?
Yes, they have given
to R5?
Yes, please have a look at page 106.
310/2025.
Yes, please have a look at page 106. 106, my lords, have that. The below mentioned landowners are hereby informed through this notice letter so and so.
That's the order.
Survey number 384 and 5.54 hectares. For this, I read to my lords at page 86. This is the same area.
310. You've charged for 310.
So today, if it is 200 meters from industrial area for me, it has to be for the other side.
Even that 310 order
Yes.
is available for an appeal, statutory appeal. Mining leases granted to third statute MMDR Act, and the rules were amended.
Please, madam.
And they permitted a third party, a contesting parties, to challenge grant of mining lease in favor of third parties. So therefore, you are entitled to challenge that.
But today, my lords, kindly
You are
appreciate.
not an outsider.
No, but kindly appreciate, my lords. Today, my application rejected only on the ground. This is 200 meters from the industrial area. I filed an appeal. It's pending from August 25. And the same area you are giving it to other side. I went to the High Court in a writ.
You are given a right of appeal against that order.
No,
What will the High Court do? How will the High Court examine whether
No,
it
High
goes
Court
or
actually
not
could have,
goes?
High Court actually could have stopped the other side to go on with that. At least I'm only requesting my laws in the
permit, you challenge it, that's the correct way. It is
that
clear from, just listen to us, we will
Please, my lord.
provide you. Your appeal is anyway pending.
Pending, yes.
In the meanwhile, this has happened, we will say that you will be entitled to. It is
And that
clear from record that the petitioner's appeal against the order dated 25/7/2025 is anyway pending before the statutory authority.
From August 25.
In the meanwhile, when an order has been passed on 3/10/2025 granting the mining lease in favor of respondent number 5, the petitioner, instead of filing an appeal against the said order, approached the High Court under Article 226, full stop. 226, which came to be dismissed by the order impugned before us. Without expressing any opinion on the merits of the matter, we permit the petitioners to challenge the order dated 3/10/2025, if so advised, and the said appeal can be heard along with the other connected appeal and disposed of expeditiously.
Can I just request it be decided the moment it's filed within a period of 15?
Expeditiously, you said.
And my lords specify the period, matter will become
In a period of
infructuous,
3
my lords.
months. All right. Next.
In fact, there's another point. If my lord just have a look at 104 also, they had in fact not even filed proper application has been granted to them. Please have a look at 104
You will have
also.
to file remedy. This should be good enough for you.
Very well, my lords.
But this is against a reassessment notice, my lord. The High Court has given relief. Not on the ground that, my lord, there was a full and fair disclosure by the respondent before the assessing officer in a scrutiny assessment.
Why?
My lord, a deduction, my lord, under section 14A was being considered.
So,
My lord, I think, my lord, I can't concede, but there is no point.
we will leave it at that. 20.
There's a delay also, my lord.
You want us to dismiss on delay?
No, it is 124 days.
Dismissed on delay and on merits.
Article 25.
Can this be had day after tomorrow, my lord? The High Court is hearing tomorrow, one day later, because there's an urgency. Chardham is to commence.
What do you want us to do? What do you want us to do? Have it on some other day?
Day after tomorrow, my lord. Day after, because High Court.
Friday.
Right.
26.
This is somewhat unfortunate. The arbitrator, my lord,
Ward. Yes.
gives a declaration that he had appeared for one group in the past.
Bias matter.
So I said, fine. But, my lord, during the course of arbitration, he continues to appear more than 16 times, to which I say, my lord, there is a clear case of bias. The single judge sets aside the award. The division bench, my lord, has a peculiar reasoning. One,
BG Chemicals has 25% in SSSMIL.
Yes.
And SSSMIL
is a listed company, is controlled, my lord,
company
by the
which
Bhaiya
appeared-
group. Of that, there is no dispute. The real question is, could you keep on appearing? And to which the division bench says, I have to say today that I am not biased. Tomorrow, if I appear, go on appearing, doesn't matter. And there's a separate, my lord, exemption for senior lawyers. And, my lord, it has to be examined, my lord. This will set, I mean, there are strong principles of independence, my lord, granted under the Act.
Bias is an issue which is available even for 34, Mr. Rohit. Even under 34, it's available.
No, maybe, but this is a very.
That's the only way. In fact, when you went before, okay, this is on 34
This
itself.
was a preliminary point in 34, which was allowed in my favor by the single judge by a detailed judgment, my lord. It is overturned on these two grounds. Lord,
Integrity in arbitration.
how can, my lord,
Build so much.
suppose I say today, my lord, I am
Problem with appointing advocates as arbitrators.
should not appoint them, or the lawyer should not take, or if he takes, he can't go on appearing, my lord.
Can't say, but then they have to be absolutely.
He can't then, my lord, either a lawyer should take, and then, my lord, the division bench says this principle applies to courts. Doesn't apply to it. My lord, how can a court is also, my lord, a judge? The arbitrator is also a judge. See, my lord, the reasoning.
34 is allowed, huh?
Yes. Why the single judge reversed by DB? Your lordship will have to examine it. Lord, this will lay down very different standards.
Notice. But the Indian approach is very different. But all over the world, this is not even a bit of bias at all. Just telling you a recent judgment of Singapore High Court.
I'll check
where
that.
I took a different view in the matter.
I see.
But I said in our case, it's very different.
But Lord, here the law is very, very clear.
In our case in India,
we are old fashioned. So we follow, my lord.
They say it's all right.
And my lord, 12-2 is direct. 12-2. Even currency, my lord, you can't be. One is initial, one is currency of the arbitration.
A bit of tainting is, it's one drop is enough to.
Obviously.
To.
One black sheep, my lord, can spoil the whole thing, my lord.
Notice, we'll just see. Let the other side come.
My lord,
let the other side come.
Yeah.
That's the in addition.
All right. My lord,
Take
have it
off
after 2 weeks. It's all right. We'll have it at
This guy,
we'll have
who
it
will
at
touch you?
2 weeks.
After notice, what will happen?
Continue the hearing.
That's item 27, my lord. Item 27, my lord. I am.
The elected term is over.
What over?
No. You 2001 elected.
No.
She was elected in 2001.
2000 elected term.
No. She was elected in 30th October 2001.
So it would be over by 2000.
Over.
October 26, my lord.
It's unfortunate.
But then difficulty would be that I will be debarred for 5 years thereafter if this proceedings are to go.
But it's only suspension order.
Suspension, then department, then
Can't be.
proceeding.
Suspension won't debar you.
Suspension won't debar me. I will always.
Final decision is not taken yet.
Correct, my lord. Final.
So therefore, there is no final order for which we
Under
need to
section
protect you.
That's right, my lord.
It's unfortunate that.
The incident, if your lordship may say, I raised the complaint. It just consider, my lord. Just consider this one. If
Today the issue is.
The page,
Now
page
you tell us,
42. Upon my behest, an investigation was initiated against the development officer in the month of March.
You threw a chappal on her.
And then I am the one
As
who
if
has been
nothing
made.
has happened.
And then Malos may see my complaint is the first point of time. Malos may have page only one request. Malos P50.
What do you want us to do? How do you want us to
simple
help you?
notice, Malos, at this stage. Was simple notice. I won't be even praying for stay at this stage.
What is a simple notice and a complicated?
I will be only without stay. Simple
You know, only
notice.
of
Notice
notices.
without stay. Notice without stay. At this stage, Malos.
What will happen?
In fact, I will be pursuing.
Your term is over now.
No, not over. October it will get over. October it will get over.
So, how are you want? We'll help you. What do you want us to help you? How does it matter?
Then they may also call for an election wherein I will not be able to contest. So if at all that thing happens, I can request your lordship.
They will call. Think about it and come back. Pass over.
Very well, Mama sir.
Think about it. And
I will.
We can help you.
Yes.
We can expeditiously ask the main proceedings to be decided. Whatever, whichever we think about it.
Very well, Mama. Let
pass over.
Yes.
May it please, Manoj. Admittedly, the High Court says it's not concurrent findings, but in fact, both the trial court and the first appeal go in different directions. But eventually, the conclusion is against me, I believe, because they have not considered the fact that this court had referred the question to a larger bench in VCK shares, which was decided very clearly saying that when you seek a declaration regarding title, that cannot in any sense go to the DRT. Now, the finding of the High Court and the impugned judgment is to tell me that I have my remedies there before the DRT, which is in the teeth of both VCK and Prabha Jain, both of which have made it clear.
Those two earlier two rounds
Yes,
were the 20th of April 93,
that's the main one.
right? We know that. That suit for declaration ended
Correct.
up in a consent decree
Yes,
and petitioner was held to be the owner.
correct. So,
That becomes the reason.
correct. So because I'm the owner, since I'm the owner,
Difficult.
respondent number one in that.
Concurrent one, concurrent.
No, just let me explain. I other concurrent, we wouldn't even bother standing up. In this one, the compromise decree is a concession made by defendant one in my favor. Defendant one therefore says on 20th April 93 that the ownership of the property is mine. 6 months later, defendant one goes and mortgages the exact same property to the bank. This I discover in 1999.
October 94.
Correct. So 6 months later, after having conceded to me, and I get a compromise decree in my favor. Now,
That's the reason.
5 years
That's
later,
provocation.
yes, 5 years
That's
later,
provocation for you now to file this suit.
that's the reason that I filed the suit. Now I seek a declaration of title vis-a-vis the bank. Either the bank has stepped into the shoes of this person who had conceded to me, in which case I would have to go file an execution. But the bank stand is different. The bank says, I have no privity with you. I was not part of this suit. I was not part of the compromise decree.
Sorry, Gopal.
No, my lords, I want to show you the judgments. Just show both weekly.
What judgment?
I've given both judgments. Just please see this.
What
First is
judgment?
Central Bank versus Prabha Jain, which is 2025. The court should have properly considered it. If your lordship sees the impugned order, section 17 is extracted in 5.5 pages of the division bench.
All right.
And it's a wrong section 17. You can't just proceed randomly in a different direction.
Well, all the courts have done that.
No, they haven't. That's the problem.
They have analyzed.
That's the problem. They haven't. The trial court goes in a completely different direction only on facts and says, look, as far as title is considered, you have not been able to establish it, ignoring my compromise decree completely. First appeal court says that section 34 is the remedy available to you. So they take a completely different stand. The division bench says,
Yeah.
what is it they do? Do they have the judgment or they don't have the judgment? Give the books, no? Just see para 42, my lords of this.
You
Beg your
don't have any remedy.
No, the problem is the
In
findings
case
of this.
property is put to sale.
Yes.
You can raise an objection. Like it will be adjudicated.
The
in
problem.
manner known to law under order 22
Correct. So
97.
let me just.
And the jurisdiction of the civil court in respect of a subject matter which is covered by a special statute.
Correct.
Is extremely limited to only to the extent of nullity.
Correct. So I'll explain why I don't have that remedy, and that's why the High Court has misunderstood thinking that I have that remedy. I'll explain why. There was an amendment.
Property is put to sale, you don't have the remedy to object. That
I don't.
Property belongs to me and can't be sold.
I don't, and I'll explain why. Section 17 went through an amendment in 2016. The previous to Section 17 situation is different from the after Section 17 situation. Previous to Section 17, there was no remedy available to a third party. I'm a third party. It's between the borrower and the bank. So I'm a third party. Before Section 17's amendment, I did not have that remedy. After Section 17, I have that remedy. That is what is clarified in this 2025 judgment. Now, the High Court looks at the post-2016 scenario, which won't apply to me.
Remedy where? Where does the remedy?
DRAT. Appeal against the section.
That's the question.
So I don't have that remedy. Now, if I don't have that remedy, the only remedy I have is to file this suit. The High Court mistakenly has given me that liberty, which is why otherwise I took instructions from my client saying, why trouble the court? We can just say we'll go to the DRAT. I don't have that remedy in law. In law, I don't have that remedy. This judgment should have been seen by the court.
It is not confined only to that, Gopal.
No, that is.
High Court judgment. It is not confined because it recounts the entirety of the history of the 20th of April 1993 order of OS for declaration.
Correct. And the High Court
How
says.
to get over that?
No, the High Court, this is what the High Court says. The High Court says.
That section.
No, High Court says all findings are left open. High Court says you can go before the DRAT. Now, either all findings are left open or they're not. If they're not, then I have to answer it in appeal. If they are, then I can go to the DRAT, but legally I can't, because the first objection the other side will take is I got the DRT order prior to 2016, you don't have your remedy under section. Can I just show your lordships the judgment for a minute? Prabha Jain, two aspects that I want to show your lordship. Just first, please come to para 42. I don't think I need to show you para 18, which says that for a suit regarding title can't be considered by the DRT. Just see para 42. I'm sorry, para 45. Para 45. I'll just first show your lordships one paragraph here, which is para 45. My lords have that? Para 45.
You read.
In Bank of Rajasthan versus VCK shares, due to conflicting decisions of benches comprising of two judges, a reference bench of this court was called upon to decide whether the jurisdiction of the civil court is ousted as regards an independent suit against the bank in the context of the provisions of the RDB Act, and whether such a suit can be transferred to the DRT with or without consent. This court held civil court's jurisdiction to entertain suit is not ousted. In the absence of any power, independent suit cannot be transferred to DRT. As there is no power, the transfer of suit cannot be done with or without. I'm so sorry. I'm so sorry. I should have.
No.
No.
You're reading something else.
My mistake. That was remiss of me. Para 45, my lord.
Where do you make the distinction? No, it's actually 127. It's not really maintainable. See, that's why we are seeing at 127. You raised a question of point, all right.
Yes.
But then what fell for consideration, the questions that you raised before the trial court, you will see at page 127.
Yes.
So you raised multiple questions.
No. So eventually the questions which are framed as substantial questions in the DB, your lordship will find at page 12 of the impugned judgment.
Just
now,
see at 127.
127, yes, my lord.
Yes, 127.
Yes. That's the trial court. Yes. No, but then after that, the first appeal goes in a different direction. First appeal admits, even the High Court admits that my title is perfected by way of the compromise decree, but says that this is not the forum for that remedy. Even the High Court says so.
These are all the questions. And these are the ones which have what affirmed in the High Court. What it is saying is that question has been considered. But then other findings will remain against you.
No, that's the problem. Now the High Court says, let me just show your lordships that. At para 22, page 25,
they may have.
In view of these reasons, the suit is filed under misconception of law and not maintainable, saying that I should have gone to DRT. Both the courts below, on different reasons, have dismissed the suit as well as the appeal. The same does not call for interference. Now, if your lordships comes previously, from page 17, you will see the section 17 extracted, which is the main plank of the judgment against me.
Right.
Now let's see section 17 for a minute.
That they have extracted a wrong unamended section
Correct.
itself is not sufficient for us to interfere.
That alone is not the problem. The problem is what your lordships have said in 2025, saying the difference between pre and post, which goes against me. That's the problem. Just please see this same judgment which I'm showing your lordships. Just come to para 22.1.1. This is at page 54. Page 54 of that book, my lords, that your lordships had. Page 54 of that book. If I can read 22.1.1, it should be at the top of the page. My lords have that? While it is true that section 17.1 uses the words, any person including the borrower aggrieved, section 17.3, this is where the change comes, does not explicitly empower the DRT to restore the possession to anyone other than the borrower.
Okay, go.
Anyone, no, just allow me, anyone other than the borrower. Yet, yes, in a given case,
what is it?
In a given case, if the borrower has put someone else in possession, then perhaps it could be contended that under 17.3, the DRT's power to restore possession to the borrower would include the power to restore possession to the person who was holding it on behalf of the borrower, claiming through the borrower. However, it cannot be contended that under 17.3, the DRT can hand over possession to someone whose claim is adverse to that of the borrower. This is the pre-17 situation. Post 17, I am someone who is not the borrower. I am a third party. So I am arguing adverse to the borrower. Only the borrower can get the restoration of possession, or somebody claiming through the borrower. I'm not claiming through the borrower because the borrower has conceded title to me by way of the compromise decree. So I am squarely covered by this judgment, which says that post the amendment, if a situation arose, you could as a third party approach. And that's why the amendment came. Parliament amended this section specifically aware of situations like this. Now, I can't take avail of this remedy at all.
What do you say, Sanjay?
There's no question of, okay, he's saying that the DRT would not have DRT, would say he would not have a remedy before the DRT. Now here in this case, what has happened is, let's say the 1993 suit on the same cause of action, okay, when let's say he already has a decree in his favor, where is the question of, okay, deciding the same question in subsequent suit? It would be barred by principles of res judicata. And in fact, what my learned friend is actually, because on the same cause of action, he had a counterclaim, Your Lordship, where he was declared, where in the 1993 suit, he already had that remedy. Now, on the same cause of action, he's actually filing a subsequent suit.
Different cause of action.
Different cause of action, but for the same purpose itself, seeking for declaration.
But otherwise also merits. Leave it at that.
Then the Lordships just record that I can avail my remedies before the...
The High Court has already kept it open for you.
No, limitation will come in my way. This is merely a question of justice. If I have a concession by the mortgager in my favor, it's a complete fraud for the mortgager to go to the bank and mortgage my property.
See this, they have already kept it open. That's there, whatever remedies you may have.
They've said liberty is given to appellants to approach the competent forum in accordance with provisions of SARFAESI.
That's it, that's enough. What more is there? Dismissed. 29.
2013.
May I just seek one small thing, because my friend is here, he's the only contesting party. He has very fairly said that my remedy is available before the DRAT. That your first sentence was,
that is there, but
first sentence was that.
Subject to
doesn't matter.
Now, either
that is
How do
there.
you want him to?
If that can be recorded, because this objection will come, I'll be back before your Lordships in 3 months.
Well, Lordship, the auction has taken place in
lawyer
2013, of which I've already paid 2.5 crores.
He's
The entire amount is
He's not the bank then. I'm sorry.
Leave it at that.
I'm grateful.
29.
My lords, the issue is, my lords, from which date the MSCP has to be granted. And my lords, the appeal is pending, my lords, and the contempt court is proceeding against us, my lords. If it would be your lordships.
How long will it be pending?
Appeal is pending in defect since 17th May 25. You don't prosecute it and then.
No, my lords, we are carrying orders, my lords. It has come up twice for hearing. There's an early hearing that has been filed by the respondent.
They are entitled.
These are the 2 orders.
Well, the High Court's order is January 25, right?
Please, my lords.
After that, what happened?
So, my lords, we filed the appeal. These are the 2 orders passed in the appeal.
Special appeal defective.
My lords, because 40 days delay is there in that. That is why it is marked as defective, my lords. Till delay is not known, it will continue to be like this. The respondent has filed an early hearing to which we have accepted. So, but after that, it has not.
To ask for an interim order before the DD.
My lords, it's not come up for hearing, my lords. Our appeal has a application for stay, my lords.
We will say that we'll grant you a status quo.
Please, my lords.
Till the DB takes up your interlock.
I'm very grateful.
Application.
I'm very grateful.
While this order in tune says what?
My lords, that directs presence and deferment is rejected, my lords.
29. Huh?
Date.
This is a single judge's order, right?
My lords, but it's a contempt court, my lords. Page 2, the last 2 paras. The deferment is rejected and compliance dealing with.
Learned Additional Solicitor General submits that against the order passed by the learned single judge on 31/1/2025, a writ appeal has already been filed, which is numbered as SA in brackets D213 of 2025. While we are not inclined to interfere with this order, we would request the High Court, the learned single judge of the High Court, to postpone the contempt proceedings till the interlocutory application is taken up by the division bench of the High Court. Till that point of time, there shall be a status.
I'm very grateful, my lord.
till that point of there shall be a status quo. No, we will not say an unending status quo
The single judge's
There
order
was
date
not
is
a
3rd January 25.
till there shall be a status quo till 31st of March 2025, 2026. We'll get some time we are giving, or else it will be open-ended.
Yes, Malad, I'm grateful, Malad.
March 2025.
Item 30.
The single judge's order is 3rd January. That is probably wrongly recorded. The
30, not 3rd?
No.
3rd
3rd
January.
January is the original order of the single judge. 20.
Which order you want us to mention?
My lords
January.
had mentioned 30. Great.
Item 30.
Lord, no material particulars mentioned in the election petition, 2 sentences. If your lordship will look at the election petition, 2 sentences, and I am put in the witness box, coerced to give evidence against myself.
How many
Against myself.
elections are?
And that is how the order is passed, that I could not read and write ODI. I have filed 4 prescriptions prior to that I have retina, retina infection. And the trial court records that and just ignores it.
So
And none of the courts,
trial court.
at least the trial court was
Dismissed. What happened?
No, I have only 1 year left.
Your repetition is dismissed. There.
My lord, I have been, my lord, just permit me 4 grounds in 4 sentences. That's all. The first ground is no material particulars. Only 2 sentences in that entire election petition that I cannot read and write ODI. The main allegation was that I am a loanee. I have not.
You are not raising for the first time. It has gone through the EP, it gone through the appeal,
Yes, my lord.
petition.
But none of them.
Arguing this for the
My
first
lord,
time, Mr. Shiva.
my lord, the second point, second ground. My lord, I am coerced to give evidence against myself. I go in the evidence. I am asked to read, and I have filed 4 medical reports which have been exhibited, which has been exhibited as Exhibit C.
Gone through all that. Thank you.
My lord, I have retina infection. I could not read it. And at least the trial court, in all fairness, should have.
Not arguing for the first time. This very argument
No, my lord.
is considered by the.
My lord, none of the courts, if your lordship will look at.
Division bench.
My lord, if your lordship will look at the division bench, it doesn't consider that. If your lordship will look at single judge, doesn't consider my retina. If your lordship will look at the additional district judge, doesn't consider. It is only the trial court. And if your lordship will look at the trial court order.
All right.
Just have a look at the trial court order. That's the only court which has recorded about my retina infection.
You're not re-examine the same facts which has gone through so many times. Thank you. Dismissed.
My lord, I have just 1 year left.
That's the ground. Next.
Very great.
But I asked for rejection of the entire claim. This can be asked even by one of the defendants. But the High Court says because 2 of the defendants have filed 711, there can't be partial rejection.
There can't be a partial.
Correct. I agree, my lord. I am asking for rejection of the entire suit. It can be filed, my lord, by any one of the defendants also. But 2 of the defendants who are the effective defendants file.
Not a party to the agreement. Defendant number 3 is not a party to the agreement. How will you seek dismissal against him?
But according to them, yes, my lord. But according to them, defendant number 3 is the distributor through whom I am now conducting business. Their case is predicated on their right to be the exclusive distributors. Therefore, they say they are entitled to continue. So they filed a suit earlier. My lord, in the earlier suit filed in West Bengal, my lord, at page 247, they lose in appeal where the appellate court says, no, you cannot invoke Indian court's jurisdiction because you have agreed to the jurisdiction in the courts at Switzerland, at Basel. But after they lose that suit, they come and file a new suit without mentioning about the previous suit. And in this suit, they add one more distributor saying that he is conducting business on their behalf in Jharsuguda in Odisha. So I go and say, Lord, I go and say that.
Sorry, Mr. Niranjan.
Lord, then may I make one
Not
request.
a case, not a case.
Lord, may I make one request? So 2000, no, 2013.
It is ordered, my lord. Your lordship may
That is
make a
ordered.
time frame, my lord. It's to the interest of both, my lord.
It's already there. You have seen that. We thought we will give you that, but that's already given.
It's already there.
Dismissed.
Great, your lord.
Similar matters,
Similar challenge was dismissed last week, my lords.
yes, same order.
Mr. Shailendra Mohan, advocate, is appearing through BC.
There's a letter in this. Is there a letter? Last time ka hoga. Last time you got a letter.
Mr. Shailendra
Yes,
Mohan,
my lord.
appearing through
Please,
BC.
my lord. Your Worship, in this case, I am challenging the order passed by the Honorable High Court by which the contempt petition was dismissed, my lord.
19 years of delay.
My lord, there is no delay. In fact, my lord, initially we filed a contempt petition in 2007. In 2007, they said that still we are not complying with, we are just implementing in soon, my lord. So thereafter, my lord, they have never implemented.
2006 is the disposed order.
My lord, 2006 order is specifically there.
Contempt proceedings. Sorry, dismissed.
My lord, only one submission, Your Worship. In 2007, we have filed this contempt petition, my lord, and that was withdrawn because they were not. They said that we will implement it so soon, but they have not implemented. In 2019, we filed again contempt petition. That was withdrawn with liberty to file a fresh one, my lord. And thereafter, 2023, then the contempt petition was filed, my lord.
All right,
The
sir.
order was.
Thank you. Next. 34.
Please, my lords. May I, my lords? My lords, my humble submission in this matter is, my lords, when one of the principals who were power of attorney, when one of the principals who were power of attorney, when he passes away, my lords, my humble submission is that the entire power of attorney will have to go, my lords. My lords, and my lords, all the three courts have relied upon a judgment of the division bench, my lords. Wherein that judgment, my lords, the operative portion says that even when one of the principal passes away, the other person, when he is alive, the power of attorney will have to survive. But my lords, they have said that it has to be decided on upon the facts of each and every case independently, my lords. In this case, my lord,
Same facts repetition. Thank you.
my lords, the respondent has sold the land to his own son, my lords.
How do we
For
do?
a very
Thank you. Dismissed. Letter? 35 में letter नहीं है? Last time.
My lords, I appear on behalf of the petitioner. My lords, the advocate on record is suffering from viral. My lords may have it on Friday, my lords. I'm so sorry for seeking this accommodation.
Next week, yeah.
Very grateful, my lords.
36, the impugned order records prima facie case, balance of convenience, irreparable injury, all in my favor. Yet there is a direction to deposit 21 crore bank guarantee. Lord, I'm just
Let me
circulating.
just
this
remind my
instantly.
lords that on the last date when it was heard on the 1st of December, my lords had asked them specifically to come back with any alternative to the bank guarantee. And I'd suggested that some flats can be kept empty and that would serve the purpose.
Lord, let me at least Lord, address on merit.
What's the alternative?
They said they'll take instructions and come back, and now.
Because we have taken instructions, but be that as it may, that's my secondary argument.
what-
my
what-
primary argument is this. There is absolutely no prima facie case made out by the plaintiffs in this.
Heard you last time, no?
Yes. My lord, last occasion, my lord, we weren't able to go through the entire list of dates. If my lords can just go through the list of dates with me just for a moment, my lord.
That's why you heard it last time. Yeah. Correct.
My lord, we have serial number 3 here. Conveyance deed of 21st December 1938 was recorded by mutation entry.
21 crores only, no?
Yes.
I'm so sorry, my lord.
21 crores.
21 crores, my lord, but
Ah,
21
you-
crores means I have to.
What are you suggesting?
Lord, I have to keep it locked up in a bank account, my lord. As a builder, it is absolutely impossible for a builder.
How else do you secure
If he keeps
them?
10 flats
Lord,
empty,
what
that
I'm
would.
saying is I'm willing to furnish an undertaking. If he succeeds in the suit, that's the end of the matter, because it's not a suit for damages that I need to provide a security that I'm unable to pay up the money. So therefore that security will make good his decree. That is not their case. Their case is that they are relying upon a conveyance deed and they are saying that this conveyance deed is legal and binding.
No, in which banner do you say that there is some kind of an interim order? See, for us to interfere, you must give us some kind of alternative that you would say that, okay, in this manner he is secure.
My lord, all that I'm saying is, my lord,
Look
I'm
at the
willing to
direction.
furnish an undertaking. That undertaking should suffice, because what I'm saying is that whatever third party rights that I've created in favor of the third party purchasers, the unit holders who have now purchased the flats, my lord, I have conveyed to them also that there is a litigation pending. So whatever is the outcome of the suit, the consequences will follow. But it is not a suit for damages, my lord, that I need
What
to pay.
type of undertaking will you furnish? That's the question. What type of undertaking will you furnish?
Say that in case
to
I
ensure-
lose, I will pay. That's all.
No, that has to be.
That's what you are suggesting.
What they are saying is. that
In
they
other
have
words, you are
entitled to
saying
a
there
land.
can't be an interim arrangement.
No, there can't be, my lord.
In other words, you are saying that that's a discussion.
At the very least, the plaintiff must then satisfy to this honorable court as to how they have a prima facie case. Lord, 1938 conveyance deed suit is filed in 2021. And 1951, there's a consolidation already. Lord, there are only three
What
persons
did
here.
the trial court do?
Lord, trial court finds that there is no prima facie case.
No, no.
Trial court finds that there is an exorbitant, huge, humongous delay.
No, no, no.
1938 conveyance.
Would restrain you from creating
Don't
third-party
create
rights.
third party.
Trial court does. High court says that yes, there
So
is
is that a better right for you? Better order for you not to create third party right?
My lord,
Which means that you will not be able to sell at all.
yes, that's
Not
the
create
trial
any
court's order.
encumbrance.
That's the trial court's order. Then we appealed it to the
So
High Court.
better off, right?
Lord, what I'm saying is, my lord, in the trial court, I was restrained from creating third-party rights. I appealed. The High Court said that yes, I have a prima facie case. I will be allowed to create third-party,
Yes, first. Yeah.
but only a 21 crore bank guarantee.
Why should Supreme Court in a injunction orders and interim orders? Why should we be?
My lord, everything is in my favor, my lord. 1951 consolidation in my favor. Then my lord may consider, may just pass it over. I'll just come back with instructions on what flats I can offer as security.
You
may just
make
pass
an
it over.
arrangement with him. Okay, pass over.
Pass.
Try and work it out. Some.
This case, an ex parte decree was passed, which has been set aside by the High Court. The condition is that I must deposit the entire decretal amount. The problem is, my lord, this petitioner before your lordship, my lord, he is paralyzed. He has
Suffered
he
ex
has
parte
land.
decree.
No, my lord, may I just, the difficulty that I want to present. He has land which is 8.5 acres. The value of the property is about 30 crores. The due even today, according to the decree also, assuming, my lord, I accept the decree, is 3 crores. The problem is that it's like killing a fly with a cannon. What my submission is, my lord, I have twofold submission. My lord, I have twofold offers. I have twofold offers, my lord. One is that if my friend may take instruction, we said that he may take a part of the land after valuation in satisfaction, if he wants it. Otherwise, my lord, one way could be, because, my lord,
My lord, 7 crores was given way back in 2007, my lord. Every 7 years, the money doubles, my lord. It's already come to more than 30 crores as on date.
Lord, the decree is for 1.5 crores with
He's
interest.
holding on to my money, my lord.
Decree is for
Ultimately,
Series of
the decree. Again, the decision has to be taken on. So the ex parte decree satisfied.
My lord, if your lordship kindly has page 107.
देगा नहीं देगा.
My lord,
Ask.
my lord, my very
Contention, perhaps what we are, and though he has not said it, what has happened is that the ex parte decree has been set aside. We appreciate that.
Conditional law.
Listen.
Ex parte decree has been set aside, and the court has said that, I mean, it is set aside subject to the condition that he should furnish bank guarantee
guarantee.
for the entire decretal amount.
Right.
His contention is that his land is already under attachment. So your interest is very well protected. In addition,
But
the
a
court
permission
should
has
not
to be
have
granted to him.
directed, court should not have directed the condition of imposition of bank guarantee.
My lord, this is such a
Perhaps that's
fair.
the only thing that we can.
I'm going further.
He is
I'm willing
providing.
to, my lord, I'm willing to even forego my right to contest the suit. What I'm saying is I'll accept the decree. I'm not even wanting any concession. All that I'm saying is,
Then best is perhaps we can send both of you to mediation.
my lord,
Why
I'm
don't you
willing
work
to
it
go for
out?
mediation. In fact, we made this offer to
Why don't you do that?
All right, my lord.
Huh? That will be the best thing. He has come that far.
my lord, may I make a suggestion? May I make a suggestion? The land is about,
Or another alternative is just if both of you can sit together, we'll take it up next
My
week.
lord, let me make an offer. I'll put it to my clients, my lord.
I think it'll work it out. It'll
I
work
think
out.
that is better, my lord.
my lord, because this man is paralyzed, he's bedridden, his brother is now looking after
Trying
him.
to sit down together.
I'll put it to my clients, my lord. I can't sit down.
Okay, come back
You
next
know,
week.
let them make
My
an
lord,
offer.
alternately, may I make a suggestion, my lord? My suggestion is the land is 8 crores odd.
We will ask Mr. Raghavendra Srivastava to mediate.
My lord,
We'll settle it.
my lord, I don't mind. I'm always open.
I don't
I'm
think
always
you have
open.
appeared. Is it all right, Sudarshan?
I leave it to your lordship, my lord.
Okay, I think we see very good possibility of the
Yes,
matter.
my lord, my suggestion, your lordship may just allow me. My suggestion is, my lord, it's 3.5 lakhs per cent if your lordship has page 107. As per even the commissioner before the executing court, the value is 30 crores. What I'm saying is, because the moment the term
What you're
attachment is used,
We
the value
understand.
falls.
We'll take a call on this.
If even a part of the land is released to me, I'll be able to get a much better the market value and easily satisfy the decree. And his interest is
Ma'am, there may be a better solution you will get through mediation. Instead of you doing that, there might be a holistic situation.
My lord, I don't mind, but my friend should only be reasonable. That's
You're
what
only saying that when you are asking us to pass orders means what? How do we do it? Then unless it's a agreed order or that or else we'll pass a order directing.
Very well, my lord. I don't mind exploring a mediation.
You want it only then.
Pardon, my lord?
If you both of you agree only, then we'll refer.
No, in fact, we made an offer. We didn't get a revert.
My lord, I'll have to take instructions, my lord.
We request with the consent of learned counsels for the petitioner and the respondent, we refer the matter to mediation through Mr. Raghavendra Srivastava, learned senior counsel of this court. List after 3 weeks.
3 weeks.
I think that should be more than enough. Is to immediately.
My lord, your lordship is
mediation.
4 weeks. He's better in 4 weeks. Your lordship.
Okay. 4 weeks के बाद date दे देना. List on so and so.
Much
obliged.
Thank you. A copy of the petition, soft copy of the petition may be sent to give your email ID. Our staff. We will ask MCPC shall give all assistance to the mediator, learned mediator, for coordinating between the parties. Next.
38.
Thank you, Mr. Raghavendra.
Here I am counsel.
And it is professionally to be done, huh?
Very well. Great.
Yes.
Here I appear as counsel.
Of course.
Concurrent findings. The petitioners are the plaintiffs. 2 courts are in their favor. In second appeal, the findings are.
First appeal was affirmed by the High Court.
Yes. No.
Reverse.
Reversed in second appeal. Now the short point is only point that arises is my title versus defendant's title. Defendant says he purchased in 1960. Inam estate was abolished in 1959. So with the vesting, where does he get title? ATM Ranga Ramanujam sells it to him in 1960.
ATM Rangaraman.
The name does ring a bell.
Not that ATM.
It is the same. It is the same.
Quite possible, he was also an advocate in Tirupati. Therefore, same person may be.
Possible.
Same person. We checked up.
RTA, road transport.
So
यहाँ पर advocate practice किया.
ATM is we used to call him Andhra, Telangana, Andhra, Tamil Nadu and Karnataka.
Yes.
Composite person.
Used to do a lot of transport cases.
both the brothers practiced in this court.
Yes. Sampath.
Yes. So, the sale, purported sale in favor of the defendant is 1960, 1 year after the vesting. So, no question of his getting title at all.
Now, title is what?
Now, the High Court doesn't even consider that. High Court says you should have filed a suit for declaration of title and injunction and interferes with the concurrent findings. That's the short point for it. Now, my predecessors.
Land revenue receipts, plaintiffs and also available. 83 sale deed they have negatived by the assistant settlement officer.
Yes.
That's another point also is there against you.
So, matter requires consideration, it's
one thing.
Page 58. And appeal was not
Appeal,
not pressed by them.
No, but let's
dismissed by Land Reforms Tribunal.
if the land stood vested in 1959, please come to.
That's what.
Your lordships have issued notice and protected us. Initially, there was a stay, and now there is an order of status quo.
मुझे भी लग रहा है, मुझे भी लग रहा है. The reasoning seems to be quite justified, Mr.
Millards, I'll point out, Millards. I'll point out. Please come to page 53.
Shall I ask?
No, what's that?
Yeah, so you tell us on these aspects.
Yes,
The High Court has recorded a finding that your vendor's title has been negatived in Patta proceedings, number one. Secondly, the High Court again has recorded a finding that the defendants have proved the documented chain of title. Thirdly, the documents on which you are relying upon, that is Exhibit A6 to A15, they do not even mention the survey number or the extent of land.
Can I deal with each one of them?
Yes.
The first two aspects are interrelated. They turn on whether the land could be validly sold to the defendant's predecessor. Now, page 53, this is an Inam estate under the Inam Estate Abolition Act of 1948 on 5/2/1959. At page 53, this is the finding. The village of Gollavani Gunta was notified as an Inam estate and taken over by the government on 5/2/1959. So, if it vests with the state free of all encumbrances, in 1960, Mr. Rangaramanujan had no title that he could pass on to the defendants. Now, the High Court doesn't even consider this aspect. High Court goes on to say that because he had a patta, now that patta is completely void because 1959, if it is his case that it is Inam land, then he gets no title at all. Whereas 1923 onwards, I have proved my title, which says that the chain of title is well established and we are not on a suit for declaration. But I am validly in possession and I have prima facie proved my title. In these set of circumstances, Millard's findings of fact, and the High Court says he had patta, therefore he has proved his title. He doesn't even produce those documents. Concurrently, both the courts hold, quite apart from the fact that the vendor did not have title.
Evidence says.
That.
There's no.
But High Court doesn't deal with this aspect at all of vesting and the vendor's title getting extinguished. No consideration.
He does put on. We'll ask him. What do you say about that point which he is saying?
Yes, Millard.
Where has it dealt with it?
That very paragraph which my lender friend started, Millard, page 57, page 57.
The High Court judgment, because it's a reversing order, we are asking about where has it dealt with that?
High Court order.
That title doesn't vest.
My lender for the first time he is saying about Inam Abolition Act and Estates Abolition Act they play. Question is this, Millard. That the ATM
there was no right vested in him pursuant to the proceedings having become final. How could he have a transferable title? That aspect of it, when it reversed it, where did it consider is what we are asking in the High Court judgment.
That is what exactly the settlement office under an exercise of statutory powers conferred this page 59. Page 59, Millard. The railway section that is allowed in favor of the scheduled.
59 is what? Not the High Court judgment.
High Court, Millard.
No.
High Court took to account this.
No, it's not 59.
Settlement office.
Not High Court.
Frankly, High Court is not gone in.
One more thing, my lord. T. Subramaniam is the person from whom they have purchased. That Subramaniam was one of the respondents in the settlement proceedings. He filed an appeal. Appeal was not pursued. Now, once you are because this demo that not quite habit, you are lashing see. Once Subramaniam's title was negated by the settlement officer and in the appeal, the purchasers from him do not get in title. And at any rate, it is a suit for injunction.
It's only an injunction.
Suit for injunction.
It's nothing more than that.
Yes, my lord. And statute.
That is perhaps the reason why it didn't bother to examine this. It's a simple suit for injunction, Mr.
And
that's
there are
right,
statute.
but if the very claim, well, I am seeking a suit, a decree for injunction in personam against the defendant. The defendant is named. defendant is named. Now, if the defendant, I have proved my title through the chain of title deeds that I have, right from 1923. If the defendant's case is false, that he says it is Inam land
It was
and I purchased
in
Inam land.
context of to grant or not to grant an injunction.
Now, therefore, if I have validly purchased and my predecessors have always been in possession, and please look at the situation.
Thank you, Mr.
Well, let's kindly put it down. Kindly put it down on a non-miscellaneous day. We'll give.
Not it, not it.
Then let me address your lordships on this aspect. Well, let's today, please consider this. Two courts have held in my favor, and the chain of title in favor of the plaintiffs has been believed. The defendant did not as much bother to produce the purported patta. Even if he did, which your lordships have seen now, at this stage, it has come on record. When the land stood vested,
Normally, concurrent findings, if they are reversed, we will see, but then he has given sufficient reasons and particular.
my lords, please see the reasons. Please see the reasons.
Injunction order.
The substantial question that would arise, my lords, if it is claimed as an Inam land, whether it vested, whether the purchase is before the date of vesting or after the date of vesting. That is the NEET question of law. In second appeal, in section 100, the High Court doesn't even consider that question. Where is the question of interfering with questions of fact?
Watching, it was not a declaratory, it was in the context of injunction order.
That's right, my lords. Then what do I have to make out? I don't have to make out my title.
Leave it at that.
My lords,
Thank you, dismissed.
my lords, just give me this liberty, my lords.
What do you want?
Your lordship said it's only injunction. Then leave it open to me to get a declaration.
That's right. That's right.
Just preserve that liberty for me because it has been pending for so many years.
Findings of that was actually clear in the High Court's order. The findings of the High Court were in the context of a prayer for simple injunction stuff. This leaves the petitioner to avail such remedies as may be available as regards the declaration of title. With this clarification, the specially petitions.
All pleas are left open.
Okay, all right, all pleas are available.
And let the High Court order not come in my way, uninfluenced.
All this
Otherwise, my lords,
litigation going on for
Injunction is sufficient, no? It's not a
one full
declaration.
generation will they are suffering.
Non-stop litigation.
very well.
Much obliged.
39.
39. Last
Settlement talks you were telling us last.
39, my lord, the settlement talks are going on, my lord. My lord, some more time, my lord. Because we want actual possession of the property. So no.
Last time you told us.
Yes, my lord.
There's one other issue that I'm just flagging. The settlement can take place, but there's an order of your lordship directing me to decide one of the representation. Now, because of the settlement, they are not coming forward with their proposal. So I don't want to
Actually,
be
the
biased with
problem is
lordship's
this, my lord.
order.
They have agreed. They have agreed in all terms.
We will grant you
Yes,
3 weeks time. After that, we'll discuss.
Yeah, after
Yes,
that, your
ma'am.
lordship.
Last.
Highly obliged.
Otherwise, I'll be in violation.
Yes, my lord.
Next.
Highly obliged.
My lords, we want to
Validity certificate.
seeking for
Deadline. The deadline was 5th of September 2025.
My lords, on the last occasion, my lords had directed that let the scrutiny committee go ahead and decide the claim of the petitioner. My lords, the claim has been decided and it has been invalidated.
2025, August 25, and notice why.
30 minutes.
Huh?
my lords, we are seeking
40,
for
right?
There is a letter.
we are seeking to file additional documents.
Letter? 40.
Yes,
Letter, no?
yes, ma'am.
My lords, the claim has been invalidated by the scrutiny committee. My lords, on the last occasion that directed.
Anyway, come back next week. Why, for what reason have you circulated a letter?
We want to file the additional documents, my lords.
What additional documents? Next week.
I'll up-
Item 41.
My lord, I appear for the petitioner. My lord, the dispute is very small. The state of Tamil Nadu is.
4.1 is listed.
My lord, only the IA, my lord, I am only asking for implementation of the report. My lord, I should point out that earlier an order was.
You have told us, we only gave them, just find out.
Yes.
What,
Now,
we
so
wanted
far
a
as-
note on this.
We have filed objections to that report.
Okay, you filed a.
But they had taken only plea in the objection regarding law and order situation, and interim order was part.
May I just?
Malad,
Please, my lord. My lord, this court has several questions to consider, including the fact that there are two-judge benches in favor of the state of Tamil Nadu.
My lord, those judgments have been taken care.
Don't interrupt, sir. We will ask you.
My lord, my lord, my lord.
There was an interim order.
You're for whom?
I am for the state of Tamil Nadu. Mr. Rodgi will also be joining in. Considering all that, this court has passed a very detailed interim order by Justice Bopanna, also considering the fact that there are two.
We have not seen this matter, Mr. Hegde. We don't really
Please,
know, but it was being listed before another bench, is it?
Earlier.
Earlier, my lords, I come now according to the roster before your lordships. There are serious questions of constitutional law involved. Today, there is a report by the Union of India, and our objection is that that report is based only on the survey of the West Coast. We are on the East Coast.
Okay, who gives that report?
The Union of India.
What do you say?
Yes, actually,
Raj, tell us.
on the last occasion, earlier occasion, Nizam court directed us to examine the issue.
What was the background? Just tell us.
Yes, actually, the
give us a little bit of a background.
yes, perceived fishing rights of so many the fishers across the borders. I mean,
All over the country.
Yes, all over the country. So to examine the aspect of their with regard to their rights and other things, we constituted a committee. Committee submitted a report. We have accepted the report. In the report, up to 12 nautical miles, it is the state which can regulate.
Correct.
Beyond 12 nautical miles, it is the exclusive economic zone that is for us to do is. Now the report has been submitted. Now the state government has to take appropriate measure either to regulate.
So your report is to that effect.
Yes, and we have accepted the report.
The report says state specific. Now, my lord, as
So
far as
their claims are concerned, that relates to wanting to do the fishing within the state's territory.
not only within, they want to
No,
beyond,
not my lord.
but through the state and
Beyond.
They want to do beyond, but then of course they can't jump.
They can't jump. They have to travel through the state's waters to reach those waters. We have expressed an apprehension in the order recorded earlier. But if you go through our water, who is to stop you from fishing in our waters also, where we have banned this system?
So
now the court ordered there would be a report. A report has come. If you see the conclusion of the report, there is completely inconclusive. And it's not
where did you file the objections to the report?
Today.
I have, but I want to show you the conclusion.
No, you have raised objections here.
Yes, I filed it here, but I want to show you the conclusion. And in any case, my lord, you have to have a pan-India policy. You can't have a policy only for Tamil Nadu or somewhere else. Because according to us,
Mr. Natraj is standing so silently. Having given a report which become controversial.
We have given the report. Now, as of now,
that side and the small
we want to protect our farmers. Because this system of
who are they representing?
The big trawlers. Perseid is a system by which if you throw a net below 1 mile long in the sea, it will pick out everything. So we are for small farmers, and if you allow these big trawlers, there will be nothing left for our fishermen. That's why we are objecting. We are not concerned with one or the other. They are big people. They can scoop out everything from the sea. We don't want to allow that.
My lord, may I request one thing, my lord? They have taken objection in paragraph 2 of their reply. Only law and order situation. Since yes, kindly see their reply for a minute.
Saying it should not be.
Kindly see paragraph 2. Only
first see, my lord, the conclusion of the report.
Kindly see only one paragraph. Paragraph 2 of their reply.
Yes.
Para 2 of their reply.
Give us a minute, please. Let us actually have a look at that report.
They are taking plea regarding.
Sir, it's come before us for the first time. We are just seeing the rest.
Report is annexed to the affidavit of the Union of India.
Got it. Page 12 se hai report.
There is already an interim order which is yes, nothing else is required.
Report kahan hai? Report. Have you got it? Where is that report?
You have
Also,
got the report
orders only.
At Yeah. Something more is also.
All sorts of documents. All sorts of documents are here.
Along with our counter.
When did you give that report?
Mulad,
Report is of 24,
24 of?
2024.
Okay.
Is the report, is the file.
After that, it was not taken up by this court.
No, because there is, my lord, a detailed interim order of Justice Bopanna.
After the report.
Before.
No, before the report.
But
The report, what happened? This court didn't examine
no,
it.
after that, my lord, it's come now. Now that interim order actually, my lord, takes care and balances. It's a 10-page interim order.
It does
It's
not.
not, my lord, a short order. I will show you, lordship, the order. It balances, it allows them. Despite my objection, it allows.
Point, Mr. Nataraj, you assist us in this.
Will,
You assist us. Where exactly do we stand? I mean, in the sense that
what
once you
should
have
happen?
given a report,
According to me, my lord, the
you have
interim
taken
order
interest of the. So according to them, union seems to have taken
Up to
interest of
12
the
nautical
states.
miles, basically.
Mulad,
state
Union of
has to-
India, your lordship,
Right, the state.
How does the right of access?
Yes, that state has to regulate,
How
number
does
one.
the right of access to those
Yes.
who are fishing beyond the state's zone and in the territorial zones of the union?
Perhaps they have to create some kind of.
You know, that is allowed by Justice Bopanna.
Mulad, kindly have paragraph 4 of Union counter affidavit for a minute, Mulad. They have accepted. Kindly see for a minute, Mulad.
They want
Page 3 of counter affidavit, para 4. Acceptance of expert report. The acceptance of
Nataraj, you tell
committee
us.
report.
Go through
That why so and so.
Take us through the report.
Very well.
We'll just see how the rights are balanced there.
Very well.
And how, if there are two exclusive zones, then it's an accessibility.
That's right.
So to say that if we permit them, then they will start fishing in the state zone. We can't prevent.
But no, there
Can't be a reason for completely denying their rights. So therefore, what's the
Justice Bopanna has permitted them.
what is the mechanism?
Justice Bopanna, I want to show you that order. Kindly look at that interim
That
order.
is before the report.
But it allows them to go from our waters.
So how does this? How does
It
this
won't,
get
report
varied?
won't change the position. Have a look at Justice Bopanna's order. Because that's a very detailed order. Have a look at that.
Bopanna का order.
Your Lordship, have the order.
Order dated 20.
Justice Radhe, Your Lordship, have the order. Now have a look at the order.
24th.
So, Milord, the judge talks about the orders. Your Lordship, turn to page 2, petitions, etc. Then, Milord.
It's an Mr. Rohitgi, just see para 14.
Yeah.
Considering the subsequent developments since 94 and the stand taken by the central government in their affidavits based on which the restricted interim order means the above two decisions are kept open, which will be considered after a deeper consideration.
That's right.
After
That's
further
right.
input.
But today it
Deeper
allows them to go.
consideration has come.
Agreed. But today, Milord, it allows them in any case for last 2 years, they are going from my waters into international.
We are not passing an interim order now.
Your Lordship may hear it, Milord.
We will examine this.
According to me, Milord, even if you look at the report.
After the report has come, the interim measure made by him, does it require
agree.
any further consideration or not?
It will require, according to me, Milord, even if when I show you the report, this order apparently, according to my respectful submission, can be made absolute and finished.
Even
We'll have to hear that.
even before the committee, they accepted our case.
Kindly for a minute, my lord.
Is this the report?
Report, Your Lordship, kindly see 257. Their stand is considered. They accepted our case. That has been said in the counter affidavit also filed by Union of India.
Chalo, we'll see this. Mr. Nataraj, go through it and then tell us.
We'll do it. We'll do it.
Milords, I am appearing for an impleader. We have artisan fisheries.
What is the point? I mean, this right with respect to fishing is controlled by which regulation will it be?
No.
So pursuant to this, final orders have to be passed. Just find out.
Yes, only final order will have to.
No, not the court. What is the regulatory regime is what we are asking. Find out. And on the basis of it, if any further regulations under which, check it up. Check up.
Milord, Your Lordship will kindly, Milord, I appear for the petition. Milord, kindly give me one moment.
Tell us.
The law does not permit them to regulate fishing beyond territorial waters.
Correct.
My lord, the report which has come, it is also on the point that they will be allowed first fishing beyond the territorial waters. Interim order is already there which says beyond territorial waters.
Yeah.
We want nothing more than beyond territorial waters. Because they have only objection. At that time when Justice Bopanna passed this order, Mr. Rohtagi's submission was that some experts are looking into the matter. So please wait. Now the experts have given their report. They say that no, you go ahead. Now, my lord, they are relying on the 94th judgment. That 94th judgment says that this kind of fishery is permitted. Now, this report given by the scientists and experts, they say that it is ecologically not harmful, rather it is helpful. Now, my lord, still it is only jig, only obstinacy of the state government that they will not allow us. My lord, only good thing about the matter of Tamil Nadu is that Mr. Rohtagi is there. Yes. Not the law made by them,
Whether it is a good thing,
which they have made, that order does not only allow to solve that order.
for next Tuesday.
Well,
Tuesday, we will go through that report and
very well, very well.
वो ना उसको flag
Ultimately, your lordship has to decide.
go through it.
Ultimately, your
Sir, please, all of you listen. Please don't unnecessarily go on and on. We're going to take it up next Tuesday. In the meanwhile, we'll go through that report. If there are any modifications, we'll pass the order.
Yes.
Take it up on Tuesday. अरे वो उसको भेज देना. Put a flag and then send it to Natraj, in the meanwhile, go through it. Also tell us, why should it be controlled by court's orders? There must be some law on the point. There must be some regulation. Just check. There must be clarity.
Fisheries,
We are addressing some, we have not asked any one of you. There must be
Fisheries Act.
clarity on the law. Just check it up
I'll-
and how regulations have to be shown.
I'll do that.
Next
Sir,
Tuesday.
On the
Next
list,
Tuesday.
top 10.
May I also
Top 10,
request to read the
Because livelihood is concerned, my lord.
one is
Top
Justice
10.
Jivan Reddy's judgment.
All right.
That is more. Can I give the citations to the court master?
Yes, yes.
They are
Next Tuesday. Next.
citation and given.
Oblige you, Lord.
42.
So your lordship said issued notice in this matter. Pleadings are now complete.
Got caught.
May I request for a passover in 42?
May I then request one thing?
Got caught in a
It will require some time.
attachment. Portion got caught in an
Let me, if my learned,
Passover.
well, may I request then one thing? If your lordships have an on NMD, it'll take about 20 minutes, this matter. Because the issue is, earlier it was done, attachment was done under 102 CRPC, which is on a suspicion of any crime. Now it's under 25 of UAPA, which requires you to establish proceeds of terrorism.
All right. We'll give it on non-NMD. में लगा देंगे.
I'm obliged.
43.
Sorry to interrupt. The date your lordship fixed.
They'll fix it up next Tuesday. Next day there. 43, 44 दोनों में. ठीक है.
Item 45.
45 is what?
This against order of
So,
MP.
पूरा
40. Lordship, 45 I appear for the appellate, my lord.
you have completely gone on now.
बोलेगा ना
Yes, my lord.
45 is,
Readings are complete in this matter, my lord.
My lord, I appear for the appellant, my lord. When the pleadings are completed, if your lordships would be pleased to keep it next week, my lord.
We will have to hear this.
Not next week, my lord. Next.
My lord, next week, my lord.
Even if
Otherwise,
last
Lord, I
won't
just
get
want to
next
point
week.
out, my lord. Otherwise, my lord, this matter has become in flux because this as
Take
civil
it,
appeal
yeah.
arises from an interim order,
ठीक
and the final order has already been passed by.
है। लिए
then what?
No,
My lord, I apologize, my lord. Lordships were not audible.
Mr. Malik,
My lords, my
he's
lords.
saying, your friend is saying that the final orders are passed.
So therefore, as on date, there is no proceeding of CIRP before either the NCLAT or before the.
My lord, the instant civil appeal, my lord, arises out of an
Find
order.
out. We will have it next week.
Yes, my lord.
If that's disposed of, then we don't need to fix a date. We will dispose it off on that day. 2 हफ्ते के बाद लगा देना.
Lord, 9th and 10th, I am not
Yes,
available,
yes.
so any
Whatever
date.
they will, उसके बाद दे देना.
Grateful lordships.
Waiting for the petitioner, my lords. The office report reflects that my lords have received a report from the Secretary General.
The report has come.
Your lordship called for a report.
Yes, yes. A report has come. It seems. देखो फाइल में खोल के देखो. क्या रिपोर्ट आया? Before the DB, the matter was pending.
Yes, ma'am.
Yes.
Ashok Pranigrahi is year after year, hearing after hearing, asking. Then you circulate it. We'll take it up next week. Give a copy to him. एक बार दिखा देना क्या है? What's the problem? It's not been heard. Why are you saying that they are not having a?
No, my lords. The office report says that 10th of February 26, copy of the letter dated 10th of February 26 attached with this office report for kind perusal of this court.
It says makes a mention but not signing it.
The Secretary General of this court issued a letter on 19th of January.
And then
Lords, I was not aware.
Who is saying that judgment is reserved?
You told us, no, that judgment is reserved.
Your lordship, initially, judgment was reserved by the then Chief Justice, my lord.
Initially,
Then
they
the
kept
Chief
it.
Justice retired.
So after that, it is.
After that, my lord, in fact, it went to one bench. We are told, my learned friend was saying, our client said, let it go to the other bench because some matters were then pending before another bench. It was doing this round.
What is it that you want us to do now?
My lords, I'll tell simply one.
What do you want us to do?
Lords, then hear my SLP.
I think so. I think
Here, my SLP means I am the respondent. Then let them argue on the next date, my lord.
Very well,
Give them
well.
whatever.
you argue. We'll go ahead now. There's
Very
no
well.
point waiting for the High Court.
Very well.
Tuesday.
My lords may then also examine the judgment that is relied upon, so which is
Whatever.
subject matter of the writ appeal.
What that Satyabrata Nayak?
Satya, yes, my lords. We'll also argue on this.
Satyabrata Nayak is enclosed here, no?
Yes, my lord.
Yes, my lord.
It is that Satyabrata
Yes.
Nayak which is pending before
Yes,
the DB. You know that?
The writ appeal arising out of that is pending. So I, in fairness, told the court that all right, we'll await. We have been awaiting for more than 1.5 years.
All right. We'll
All right,
see.
my lord. Let whichever.
Deeply. We will hear now.
Yes, very well. My lords.
Lordship, in item 47, we are being led by Ms. Pinky Anand, senior counsel.
You are sitting here only? What happened?
She's in
47?
Gujarat. She's in Gujarat. Ms. Pinky Anand.
अच्छा अच्छा.
Lordship, can kindly have a short adjournment.
क्या है ये national?
Any short date.
Okay. At the request of the council for the
The shortest possible date.
Document of compensation.
compensation.
The case where, Lord, is a strange case where compensation since 2018 has not been paid. Lordship ordered pay the compensation, then it
Our order.
said it,
But like
put it back.
an amount of 69 lakhs
Yes.
has already been transferred, no?
But then we've been asked to
more?
deposit it back. That's the problem.
There was change of roster. So
It said deposited back and to put us to some terms and conditions. Section 34 over, section 37 pending.
amount is still lying in the court.
Back.
We've deposited it.
Why?
Why? Why?
Just there's an order. Put me to
No,
some
about the
terms.
calculation. How does that question arise?
No, we're the petitioners. If they requested that, ask them to deposit it back, then we'll put them to some terms. And this is the original amount, my lord. This is not the enhanced amount also. And in fact, this is less amount. This is not even the complete amount. Their 34 has been dismissed. What they are saying, Lord, I have no objection to the adjournment, but just so as to put it in perspective, they are saying, though the land is vested in us under the NHA Act, it vests automatically, but we have not taken possession, therefore we will not pay you. That's the short point. And the High Court says, since they've not taken possession, don't pay. The question is, what is this time frame with 2018 acquisition? 15, sorry, it started in 15.
Now, actually, possession is with whom?
It's with them. They've demolished our structures.
Possession is with them.
That again is a controversy.
High Court. According to that, the possession is with them only.
Lord, can it be forever and ever that they will not
Because
pay
Your Lordship-
compensation? Either they should say they don't need this land.
Yes.
We will
That
pay
they
the
don't say.
Can't be.
Compensation
No,
and
my-
release the land.
No, my lord, if I may, our only objection is that the 69 lakh rupees that we had deposited before this court pertains to all the landowners, including some of the landowners that are not before this court. Competent authority who is the disbursing authority.
You tell us, we will pass it over, we'll hear you.
Competent authority.
We'll hear you.
What happened was the entire amount was given to petitioner number 1, and he himself decided who is entitled to what amount.
You are ready, wait,
paid the
we'll
money.
finish other matters and we'll take it up.
Yes, ma'am.
Yes, next. We'll take up this. Yeah, what is this unnecessary confusion?
Please, my lord, on behalf of the respondent, my lord, I'm seeking an accommodation of 8 weeks, my lord, on account of maternity leave of lead counsel Ms. Anupriya Gupta, my lord.
Unacquired land becomes useless. No, that's the only small portion is cut. What's the problem?
My lord, I'm seeking 8 weeks of accommodation, my lord, on account of maternity leave on the lead counsel Ms. Anupriya Gupta, my lord.
Just after 8 weeks.
I don't have an appeal.
49.
Please, your lordship.
लिस्ट वो उसको डेट ही दे देना, कोई लिस्ट मत करो, वो जुलाई में लगा कोर्ट खुलने के बाद. नेक्स्ट.
May I please, your lordship. Your lordship, this is the case of a cooperative society, and if the fight is between
Those
some.
pub dealers.
There's a chawl on the property. We have, our society was set up as early as in 81. As per the agreement, the promoter builder.
Want the land to be transferred to it under the act.
Today, I'm today actually suggesting a solution, because the tenants are with us. The property is in extremely dilapidated position.
But your writ got dismissed.
We're willing to even buy this. I'm just saying, if one round of mediation is possible, we are willing to buy 100 months of rent, because that option is also available with us as per the agreement. If we can sit across the table today, tenants are with us, your lordship. There are 30 tenants. And the BMC has already issued several notifications saying it's on literally complete.
Look at the clause. Huh?
One,
okay.
My lord, concurrent finding of fact, my lord. There is concurrent finding of facts in this case, my lord. And the issue that they are trying to now bring out, my lord, on a mediation, I'll take instructions if my lords are indicating that. But otherwise, my
settle
lord,
it. If it is possible, settle it. They will give you some money.
my lord, I'll take instructions, my lord.
I think that may be a better solution.
My lord, may keep it for Monday. I'll take instructions, my lord.
Shall we straight away refer it now instead of that?
Yes, my lord. May refer it, because if I have instructions, the mediation will
This is from
continue.
Maharashtra,
Otherwise,
is
it will be a non-starter, my lord.
Okay.
To the Supreme Court mediation.
My lord, may I request if my lords can keep it for Friday or a Monday? I'll take instruction. Otherwise, it will be a futile exercise to go for mediation. I don't know what the.
What is there? I think there will be some solution.
I believe so.
Refer it to someone from Maharashtra.
Lord, that may also be feasible, ma'am. In Bombay, if they can refer it to Bombay High Court under the Bombay High Court, it will be easier there, my lord. Parties are there.
And go and sit. See, they'll also not benefit ultimately.
The parties are in
We'll
Mumbai.
refer it to, that's a good name. Mr. Justice Barlapalli will be the best person to.
If it's not possible.
We'll refer it to it. Huh?
Please, my lord.
I think, having heard Anita Shenoy and Mr. Amarjit Singh Beri, we are of the opinion that the matter could be easily resolved. For this purpose, we refer the dispute to for mediation, to Mr. Marlapalli, Pura naam likh lena, the former judge of so and so, for mediation. The terms of mediation will be determined by the learned mediator in consultation with the parties. List the case immediately after report is obtained from of the mediation report is obtained.
I'm obliged.
Right.
Sir.
That will be a yes.
Obliged.
Yes, Amarjit Singh. You also try. Tell your clients.
I'll do that.
My lord, these petitioners, my lord, they are retired employees. My lord, the division bench judgment has been upheld by this court. SLP dismissed way back in 2019 of employer as well as the state. My lord, we filed contempt petition. My lord, the contempt petition has been dismissed by the court by saying there is another notification which has been issued. And my lord, that
what have you done about that notification? Have you challenged?
My lord, we did not challenge. My lord, our other colleagues they challenged. And
How you not challenge the
no, my lord,
problem which is arising?
Our rights were crystallized, my lord. We were in category 2, we are already retired employees. And against that, my lord, the state and the employer came here. Their SLPs have been dismissed in 2019. So then we filed contempt that they have to comply with the order in respect of those employees who have not got CPF but they are opted for pension. So those regulations have been upheld. And even now, my lord, that meanwhile, what has happened, my lord, that order by which the division bench said that you wait for the outcome, even that has been dismissed, my lord. The appeal has been, it has been allowed.
After 2018, we'll ask you. After 2018, what happened, Padmesh?
2020, there was again a fresh notification in 2020.
But does that cover these people?
No. Yes, my lord, that's what I'm pointing out. 2020 notification was challenged. But just last week on the 19th, my lords, the Honorable Division Bench has then set aside that order. So, my lords, the state is, my lords, considering the implications of this order. If my lords may have it after 2 weeks, perhaps, my lords, the state will be.
Are you aware of that?
No, yes, I have that order.
But in any event, whether that notification, did it cover them or not, is the question.
The short controversy is whether, in terms of the first judgment, where Section 48 compliance was required on that ground, the withdrawal of pension regulations was set aside. Subsequently, after complying under Section 48, fresh notification was issued. The short controversy is whether it can retrospectively apply or not.
But so far as the judgment of the High Court in 2018 is concerned, it was in their favor.
I bow down.
That judgment must have culminated in your 2020 notification. According to them, it didn't culminate in 2020.
The controversy there was a 2004 notification which was set aside on the ground that Section
by the
48
judgment
compliance was missing. Now, my lords, while the contempt was filed, there was another notification in vogue. By the time these contempt petitions came to be decided, even that notification had come to be withdrawn and a notification issued in June 2020 was in vogue. Now that
what's the remedy for them?
But
this is
lordships will have to
say that
examine whether the act allows us the power to retrospectively apply after compliance under
it
Section
appears
50.
that the 2020 judgment has become final.
Yes, my lords.
And in which case the contempt is.
Therefore, my lords, in subsequent orders, a specific liberty was granted to the state to undertake actions in accordance with law. Now, therefore, my lords,
contempt on the ground that.
He has passed on the judgment to them.
Please, my lords. Well, because this was only uploaded on the 20th, I was communicated yesterday.
My lord, may I say, my lord?
Come final. Then
in 2019, my lord, SLP dismissed, review dismissed, my lord, 2018 order.
You also find out about that.
Lordship.
Find out about the latest one and then tell us how that notification, in any way they have withdrawn that notification. Have a look at it. You come back next week.
Yes. Yes, my lords.
Post after 2 weeks.
Mr.
Padmesh Mishra informs us that a notification issued pursuant to the judgment of the High Court in 2018. What exactly is the?
Well, 29th June 2020 notification, which has subsequently been set aside.
No, my lord, prior to that, there was another
Set aside, is it?
Yes, my lord, this judgment that I've just handed over.
against them, my lord. Again, it has
It is
been
against
dismissed.
us.
How many rounds, my lord, they will have for
Therefore,
these
my lord, the
employees?
question would be whether if it is put to challenge, my lord, both matters can be heard together.
I'm sorry, my lord, this order.
Was this challenged?
No, this is last week, my lords. On 20th, the order is uploaded. This is a 19th February order. We are today on 23rd, my lords. So
The pension matter, why are you troubling people like
I
that so much?
bow down, my lords.
My lord, may I
The
read this, the
pension
two
matter.
paras of the judgment, the way
In
High
fact,
Court has
this-
lamented them, that you are harassing the employees by filing SLP dismissal. After that, you issue notification. That is, my lord, again set aside. Third notification, my
This
lord,
is under Act.
Which state is this?
State
the
of
state of Rajasthan, my lord.
What is this?
No,
I'm very unhappy that you.
Well, I bow down, my lords. If, my lords, therefore, since the state is examining the recent judgment, it's been 3 days, my lords, since this judgment has come.
But
to me.
according to them, this judgment didn't have any implication on the order passed in their favor.
Yes, my lords.
Then how does it? It's like a blind eye.
May I
Closing
just-
or
may I
opening,
just
it's one
point
and the
out,
same.
There are 3 notifications. There is the original judgment, which challenges the 2004 notification. That is set aside. Against which, my lords, a contempt is
Wait,
sought.
Pardeep.
In the meanwhile,
Okay, what do you want? You
well,
tell
my lords
us.
may have it after 2 weeks. The state is examining this judgment. If we come in appeal, my lords, let both matters be heard. It may be decided.
But we'll take a serious view on.
I'm grateful, my lords.
Don't take this for granted.
Yes, my lords.
Lord, I just want to take your lordship to para 44 of the judgment, my lord.
Doesn't matter. We'll just see.
Lordship. At page 36, internal page 36,
I
para 44.
We're just
take
making
it
a
against
note
you,
of
my lords.
it.
There are scathing remarks against the manner in which this has
19
been
to
dealt with, but
2006.
I'm
You
entitled.
will get more scathing.
Right.
And we'll ask you. No, we will not give a scathing remarks. We'll just
We will
send
then
your.
hope, my lords, that we are
We'll
able to.
straight away send your people to jail from here directly. You can't trouble people with case after case when you don't have to comply with the orders. You take instructions after 2 weeks and come. Which was said.
Can I pay
Right.
for the date, my lord?
Give a date.
Lordship. Great.
Obliged. The counter affidavit of the Union of India is awaited.
Well,
Awaited.
it's 3 and 4, which are the relevant respondents, they have filed. I'm appearing, my lords. And this matter, my lords, I would say that this has been a continuous round of litigations,
Lord,
one after another.
For all
It has
poor
been
mess workers and
1 minute.
been dismissed, my lords. My counter affidavit,
Cooks.
my lords may kindly see, there is a list.
Parity, is it?
Yes, but there's no parity.
Special allowances.
special allowance given to nurses, librarians, doctors.
Yes.
After all, mess workers will not working for morning 5.
Sex workers.
Wait.
Why? Government of India has to answer, not the Navodaya Samiti. Why should my friend be so concerned? Let the Union of India come and respond.
She's for union.
No, she's not for union.
I'm for 1 to 4. I say.
She has whether engaged or not, she is an additional Solicitor General. Whether she doesn't like also, she'll be bound by our. We will bind her to appear for union.
No doubt she
can't escape that.
No doubt she is very competent than many of us here. But as far as the counter is concerned, it is only filed for the other respondents, not for Union of India. So, and they had supported us in the High Court.
You lost both CAT and High Court.
Many rounds. my
They say res judicata. Sympathy ground, is that?
Poor mess workers and hotel workers.
They say they work in remote areas.
Remote areas and hilly areas. All others are given.
What do you say?
lords. I say,
It has to be heard. You want to argue or it is being contested?
my short argument.
It's a contest, is it?
Yes.
Yes, my lord.
No, apart from the order dated 17/12/2025, by which their original application was disposed of with a direction to consider their claim, are there any other orders by which their claims have been negative?
There is a chart, my lord, which is there.
Where?
Yes, in my counter affidavit, my lords may kindly have at page 4. These are all cooks, one after another. The single individuals have filed. This has come till this court and then also till High Court, man. Kindly see, these are the OAs.
All right. 7 OAs.
Yes. And they are claiming parity with the teachers, my lords. The teachers, because
equal paper, what issue?
Lord, earlier applications directed the government to consider. Lord, every time it was remanded. Now this time say your OA is barred by limit.
Parity, Mr.
Parity,
So
Mr.
therefore,
That's
we'll have to consider
we have
that.
to consider as well.
Okay, all right. दे देना, डेट दे देना. डेट देना कोई ट्यूसडे या फ्राइडे के दिन. डिस्पोजल का लिस्ट में लगा देना. We'll give a date and then do it.
Better than 5, no? The Union of India.
You file that counter in the meanwhile,
1 and 2, I'll
drawing out the distinction. Okay. Respondents 1 and 2 shall file a counter affidavit in the meanwhile, drawing out the distinction between the petitioner's case with those with whom they are seeking parity. Yes. This again will take some time.
My lord, it will take some time because I need to point out certain things. But these people have scored abysmally low marks, my lord. So, and they have no vested right because they have.
This will have to be heard, my lords.
Yeah, that's
correct.
what I think. We'll hear.
My lords, immediately after the holy vacations, because your lordships, my lords, on the last dates, my learned friend wasn't appearing. Somebody else appeared, said that we'll get further instructions. And no affidavit has been filed.
We will decide it.
Yeah, let's
Joined to the reply which has been.
Why now
filed.
we have adjourned enough? We'll hear.
Yeah, absolutely. Please.
We'll hear and dispose it.
Just file the rejoinder in the next.
You do that.
The connected
meanwhile.
item 75, my lords. Respondent number 4 to 105 can be deleted. Their pro forma response.
Where is Mr. Manish? Okay, anyway. इसको भी एक डेट दे देना. Some clear date दे देना.
My lord, these two matters are different. My lord, the state of Assam is in the first two matters. The other matter belongs to state of Maharashtra.
It's tagged
So they
along
can
with
be
this matter.
Issue is common. Issue is common.
We'll take them together only.
Yes.
Respondent 4 to 105 can be deleted in item 75.
It's become a modus operandi now for all states, my lords.
You're right.
My learned friend's suggestion to put it to me that I should put
In
it.
my case, my lords, they have continued on the basis of interim order. So I have a different case. I'll point out.
Correct. I'll show.
Okay. Date दे देना. We'll give a date.
Very great.
Sometime when there's sufficient time, we'll give.
In March, if your lordship, some date after.
Yes.
Very good.
We will do that. We will delete those respondents.
4 to 105 and item 75.
4 to 105.
Lords, in connected matter, my lords, I want to file my
1 minute are deleted. The risk of the petitioner, as they are. पता नहीं क्या है, whether they are necessary. Who are those?
Well, they were the petitioners before the High Court who are not.
At the risk of the petitioner. Next.
Grateful.
I'm obliged.
The precise question as to who has committed the breach, whether it is the plaintiff or the defendant, has not been considered. Covered by section 73 and 74 of the Contract Act. Lord, there is a forfeiture clause here.
53.
Which says, Lord, I will just read page 34, Lord.
Give us some facts, Mr.
Except, Lord,
सुनेगा.
there was an agreement for sale between the
सुन लेंगे.
The decree is only for return of the advance paid during 2012 with 6% interest. Only
Yes,
the
that's
amount
all.
that have paid in 2012.
take your
Now he has deposited the entire money and benefited because he is getting 8% interest.
No.
Yours is a suit for recovery, no?
Lord, kindly see.
Mine was a
1 minute. 1 minute.
I don't understand why the respondent is arguing first. Lord, kindly see section 73, 74 and also the forfeiture clause in the agreement. Kindly see section 73 of the Contract Act, my lord. Can you have 73 and 74, only two sections. 73 and 74.
What is the big question of law?
Exactly.
What is the
Covered by
question of
73.
law? Because both the courts have
Will kindly see section
recovery only.
Kindly see section 73 of the Contract Act.
70.
When a contract, can you read me out section 73? Compensation for loss or damage caused by breach of contract. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract.
What is new about 73?
Nothing new. In which case, kindly see the forfeiture clause. Kindly see page 34.
Show us the forfeiture clause. Huh?
This is the forfeiture clause.
That's
In
the only
case-
thing you will have to see 53. 1 minute.
Yes. 73 and 74. Who has committed the breach? If the plaintiff has committed the breach,
But those are the findings, Mr.
exactly, my lord. There is no
Concurrent findings on
no,
that.
no finding is my problem. Both the
Page-
trial
page-
court,
page.
kindly see page 34 is the forfeiture clause. Page 34, my lord, of the paper book. In case of default,
By the second party for getting the
in
conveyance.
case of default, by the second party for getting the conveyance executed, second party is the plaintiff. Within the aforesaid period, the advance amount paid shall be adjusted towards the loss suffered by the first party, that is the defendant, and this agreement shall become cancelled, and the second party shall not be entitled to get back any amount or to get the conveyance executed. And further to the expiry of the aforesaid period, the first party shall have all the rights to deal with the scheduled property in any manner to sell the same, and the second party does not have any right to question the same. If the plaintiff has committed the default,
The
the
second
defendant
party is the plaintiff, right?
the second party is the plaintiff and the first party is the defendant. If the plaintiff has committed the wrong, the defendant is entitled to appropriate. If the defendant has committed the breach, the plaintiff is entitled to refund. Now, where is the finding? Where is the finding in the appellate court or by the trial court that it is the plaintiff or the defendant who has committed the breach? No finding. Absolutely no finding.
We'll ask them most probably.
I
We are assuming that. Is there a finding or not?
My lord, it is not necessary to render such a finding because
It's a simple recovery, but it's a forfeiture clause, right?
when a forfeiture clause is there, but it falls under section 74. That is what this court said consistently. It falls under section 74. For the purpose of invoking section 74, they'll have to show that this damage has been caused to them. Both the courts have concurrently found that no damage whatsoever has been caused to them. My lord,
74 also, the Telly Oates judgment. Telly Oates is under 74 only. Have you seen that?
Well, I've seen that. That Kailash Nath, the latest
Kailash Nath is referred to in Telly Oates. if
Yes,
I'm not wrong.
first judgment, my lord, which I refer, my lord, is that is
Telly Oates in the forfeiture clauses, how they work out, they have very clearly indicated that it won't automatically follow. Shows that.
may place reliance on, my lord, this judgment.
Telly Oates.
Fateh Chand, Telly Oates, my lord, have not brought, but again, Fateh Chand, my lord, may one sentence.
Fateh Chand is the main judgment.
Fateh Chand is the main judgment. My lord, can you see paragraph 11? Paragraph 11 of Fateh Chand, my lord, towards middle. Towards middle. Fateh Chand. Please.
Which page are you showing?
Paragraph 11, Fateh Chand, my lord. Sorry, my lord. The wrong judgment has been handled.
This is the most famous judgment.
Their contention in the counter is this forfeiture clause
is in fact there or not?
My lord, paragraph 11, my lord, towards middle, my lord, should find.
It's not necessary.
My lord, one sentence. In our judgment, my lord, get that page 11 and paragraph 11.
Yes.
Towards middle. In our judgment, the expression contract contains any other stipulation by way of penalty comprehensively applies to every covenant involving a penalty, whether it is for payment of on breach of contract of money or delivery of property in future, or for forfeiture of any right to money or other property already delivered. Therefore, forfeiture would fall under section 74. Now, my lords,
Not to be enforced in penalty.
my lords, may kindly see Kailash Nath. Kailash Nath. In Kailash Nath, my lords, conclusion.
You are right, actually. Yes, Kailash Nath also says so.
Kailash Nath also says so, and ultimately, in the concluding portion, my lords, may kindly see Kailash Nath, paragraph 43.3. Since section 43.3.
Whether or not actual damage. Whether or not actual damage. Whether or not actual damage.
Who has committed the breach, not the damage? Who has committed the breach? Where is the finding? I read
One minute.
My lord, can you see page 50, of the trial court judgment? I mean,
There must
page
be some
50,
semblance.
paragraph 12. Page
There is some kind of a reference. It can't be that there is nothing at all. In fact, they formulated.
Page 50 to my lord's paragraph 12.
You're right.
May I read?
Yes.
That further contention of the defendant is that due to the sale of part of the property situated in the middle of the plain schedule property, after providing a way to it, the value of the remaining property situated on the back side as well as the front side has decreased. However, apart from the ipsi dixit of the first defendant, there is nothing in evidence to prove that the value of the remaining land has decreased. And in the normal course of events, the land value in Kerala increases by passage of time.
That's right. We were about to say that.
This has been affirmed. This has been affirmed by the
It's a natural, no, Mr. Chidambaresh.
Kindly see below page 8.
That is natural. It's only a technical point.
Page
Anyway.
8. Page 8. Page 8 below paragraph 9 towards the middle. The solitary sentence in both the judgments searched together towards the middle of paragraph 9. Even assuming that the plaintiff was responsible for not taking forward the agreement, still unless the defendant proves that any damages resulted consequent on the non-performance, they are bound to return the balance amount. Where is the finding?
55?
50?
Third counseling,
Minus
right?
50,
This
50.
batch has now to.
Minus 54.
54, I think.
54. Oh. No reservation for OBC in. Oh, no. Yeah, this is that Gawai's order. This is that order. What we were saying that he's been edged out. Whether this man could be accommodated is the only question. There's nothing, no question of law, because it wasn't part of the notification. And seats were not to be allocated to the reserved category. But then the court passed an order, as a consequence of which these people have gone out. There's nothing we can do about it. But just if you take instructions, if it is possible to accommodate them.
For this year,
It's too late to
yes, it's
check up about next year.
Well, it's
Take instructions. Take instructions. If we can. We told them that it is not as a matter of right, because there's no remedy against a court's order like that. There's no illegal action of a government here. It's a consequence of a court's direction. So if you could do that so that to balance the interests, take instructions. You will have to ask whom? MCA?
have to pass an order, alerts for the next year, because for this year, the process is complete and the 6 months have already gone by.
What did you do for the next year?
My lords, I have taken admission, my lords, because
You've already taken it.
my lords, but I am waiting for this because the thing is when the
You've already taken admission, right?
my lords in a private
No, you understand the position in which
my
we
lords,
are.
I understand.
It's not a governmental action. It's not a governmental action that we can set aside. It's a court's direction and the consequence of the direction.
My lords, the only prejudice which affected me was when I paid it.
You lost 1 year.
My lords, not only 1 year. I was in the queue, 3 seats. It never said that the general category seats have to be given to the OBC. My lords, that's my prejudice, my lords.
All that we can say, it's a lesson for us. So we'll close this matter.
My lords, please, if they can take instructions and come up, because
You've already joined somewhere. We don't unnecessarily put you.
my lords, it's very tough to get such type of seats in a government. It's a state of the art. My
What do we do? That term is all over.
My lord, this is also one of the difference, my lord. The amount of fee difference will be one of the factor, and the factor is that I worked very hard. I got the admission when I gave the prospect.
You got this time you took a management seat, is it?
No, MBBS, my lord, MBBS, but the
Private.
Are you paying? Man, this is a free seat.
I get what my lord is saying, but my submission is, my lord.
No, how except for the loss of 1 year, how else? What is the additional prejudice that cost to you?
My lord's financial.
Financial, you would have paid then also.
But the difference is, there will be some difference. And
what? That's what we are asking.
If we leave apart the financial side, let us leave that. But the quality of, I belong to that state. I have annexed 3 affidavits in my special leave petition, which says that I have given up my pool quota because I was from different states. So I have lost that right as well. I have lost that right as well. Now, my prejudice is that I was in the queue. It's not that.
Earlier also, it wasn't clear where you got the seat. Which college did you get?
Now I am in Chandigarh. I applied for which I have filed the special leave petition is for the Chandigarh Medical College, Government College Chandigarh. I have taken admission somewhere else. But my difficulty is, my loss, that I was 107, petitioner number 1, 2 and 3.
Sorry, there's nothing.
My loss, if my loss may
Dismiss.
consider page 84, my loss, because
There's
it
nothing
never
we
said the seats have to be given to the OBC category. My loss, the way
That's
they have,
okay. You know that.
I understand.
Because of the court's
I
order.
understand, my loss, I understand.
55.
Public.
May I please file a counter?
Getting a copy, it's not on record. Your lordship's permit,
I
can
just
place
want to
it.
make one brief submission. There are 55 and 64. There are
There are
three.
some more, are there? Huh.
Yes, there are 3 matters. I'm appearing 2 of them.
We'll have to
The-
examine the policy decision. Where is
that-
your affidavit?
That question has to be examined, but I just want to make one submission up front. There are approximately 2.30 lakh students who sat for the PG exam. As a result of this relaxation.
There is interestingly another case which came before us.
Yes,
Saying that it must be reduced further.
More than 0.
Negative.
Never said 0, but
So we asked,
that it should be
how is it possible? We posted that matter also.
Yes, my lord. Item 65.
60. You are appearing there.
Now, out of the 2.30 lakh, the normal process is 50th percentile above is treated as qualified. So 1.15 lakh apparently is qualified for the total number of seats, which are about 80,000. As a result of this relaxation, because there's only one thing in respondent one's mind, which is we must fill up seats, nothing else, no consideration about merit, etc. Your lordships and PT Srivastava, the bench has specifically said filling up seats is not the priority. The priority is to ensure that the best education receives the best, most meritorious students, and therefore treatment of patients.
This is postgraduate.
As a consequence of this relaxation,
Srivastava is not postgraduate.
no, specifically PG, specifically one para 56, specifically on PG. Now, as a consequence of this relaxation, out of the 2.30 lakh who sat, 2.28 lakh are being considered as qualified and are being given admissions, despite which even now in the latest affidavit, they say they have 2,988.
We'll examine the policy, Gopal, and what made them take a decision.
Yes, so this present last counseling gets over on 24th.
Urgency, is it?
I don't see the urgency, honestly, for them to fill this up.
Have
After this relaxation,
you filled that up?
Yes, my lord.
they have 2,988 vacant. That's what their affidavit says.
Those people have.
May I just also add, this has been done midstream, my lord. This is after the second round of counseling that this reduction has been done to make it a non-starter, my lord, totally.
Completely.
Who is she up here?
It's after the
Also
second
with
counseling.
us, with us. Miss Anand.
I'm appearing in 55. Yes, my lord.
Yes.
Where exactly is the policy?
Well, that's page 11 is the of the counter that I've handed over to your lordship. This is the minutes of the meeting, my lords.
We don't have.
Page 11, your lordships don't have, my lords. The last.
It's the last 2 pages.
There's only one annexure here.
Yes, that's the only annexure.
The minutes of the meeting.
That's
It
it.
is
What?
chaired by DGHS. List of attendees, your lordships will see.
No, but then there is no material apart from just the decision here.
Well, I have asked them to give me the data which was
Some
given to the
background
committee.
leading to this decision, right?
Yes, so the decision in para 5 mentions the data from the National Board of Examination. There is also data from the previous years. This is not the first year.
Data can't be reasoning.
That is what we want to know. Exactly what you will have to tell us.
In case the
After detailed deliberation and examination of the data provided, so therefore you file an affidavit. You file a detail. This is the affidavit.
Yes, ma'am.
This is the. Let us see in the affidavit how do you justify this decision?
Para 22.
I'll place it.
No, the answer is
please
para
see-
22 is the reason.
See para 6, from para 6 onwards, my lord, page 3. Eligibility criteria to appear in NEET PG requires a candidate to possess a recognized MBBS degree and to have completed compulsory rotating internship. All MBBS candidates are required to secure at least 50% marks separately in theory and practical examination in order to qualify the MBBS degree. All such candidates have earlier qualified NEET, UG or other competitive entrance exams to secure admission in MBBS. Admission to MBBS is strictly merit-based through centralized counseling. Therefore, all candidates appearing in NEET PG are academically meritorious individuals who have successfully undergone 4.5 years of rigorous medical training across approximately 16-17 specialties of modern medicine, followed by 1 year of compulsory internship. Thus, every candidate appearing in NEET PG is already a duly qualified.
This we thought you were going to say, but over and above that, what is that? That's the point of distinction.
Point number 7, your office will see the manner in which this examination ranked.
Third in a competitive ranking examination.
200 multiple choice questions carrying 4 marks with a total of maximum 800 and incorporates 25% negative marks.
Total seats and vacancy.
And then, my lords, total seats and vacancies is the third aspect. 2025-26 total seats available were approximately 70,000, corresponding to total number of candidates of 2,24,000 odd, while a total of 31,000 were available under All India quota across various specialties. After round 2, counseling, a total balance of 9,621 remain vacant under All India quota. And therefore, my lords, then we have given
You can skip.
further submissions.
An issue. Hereafter, the seats become vacant.
Para 10, your lordships will see, this is the precedents on this.
Just we will take because this has not happened just this year. It's
Yes.
No, it
It's
happening
happened
year
in
after year.
2023, yes. Can I,
It's happening year after year.
that's why one of the petitions, one very serious issue, I mean, it's a public interest issue. Of the seats that are going to government, in the government category, the fees that are being paid are between 9,000 and 27,000 per year. The fees that come from to the private colleges is 1 crore to 1.5 crores. Now, if instead of, and this is something they should consider as regulators, instead of just reducing
Is 9,000 to?
between 9,000 and 27,000, while the fees
Oh.
in private is between 95 lakhs to 1.5 crores. In one of our prayers and one of our petitions specifically about this. Instead of reducing the percentile to this absurd 0%, what you should be doing is ensuring that the fees are not so prohibitive. So many students who have the merit are just can't pay. If you have to pay 1 crore, it's like a foreign education. 1 crore you can't afford. So those students are not able to take that, which is why it may mystify many of us that when you have 1.3 lakh available up to the 50th percentile, why aren't you filling up 85,000 seats? Because the fees are so prohibitive. That's why you have to keep going lower down so that rich people are able to afford this. That's effectively what is happening. Now, we can't have a monetary relaxation of this sort.
It's a serious policy.
It's a very serious issue that needs to be
Serious
considered.
policy issue.
Challenge, fee regulation has been. The fee regulation, Malats, the NMC brought a fee regulation in which they stipulated that a bracket in which it cannot proceed, which is 50% more than the government college of that state. But that, Malats, you're allowed.
That's
But they're violating then, full violation.
Neither NMC nor the Union of India have anything to do with the fees, my lord. It is done as per the Islamic judgment is done under the supervision of the retired
Whether
judge.
it's
Fee fixation committees.
adversely, it's affecting the quality of education is what
yes.
we
That's
are concerned more
that's
than
exactly
anything.
it.
More than anything, it's about the quality. You will have to satisfy us that the reduction of the cutoff so drastically, virtually bringing it to zero and non-existence, though you were justified in saying that this is not like entry into MBBS, this is like a post-graduation. It stands on a different footing because those who apply are already doctors.
It's comparative merit.
But still, in the context of competition, you'll have to be reflecting.
Yes, also what happens is
We will
here
put it
it
up.
is
Put it up.
not only 0
Five judges.
percentile, it's minus 40 cutoff, my lords. Where you have negative marking, you'll become a doctor, my lords, and super
My lords,
specialty.
can you formally issue notice in all the petitions?
Notice is already there.
No, it's only in one. It's only in one matter, not in all.
In my matter, my lords, has been issued, I believe, maybe.
21st को लगा लो, 21st is all right. 21st, post of
But
21st.
my lords, formal notice. It's
Good.
only gone in one matter. I just
All of you respectively take notices, issue notice. Issue notice,
no point.
file
Well,
necessary
let's-
compilations and return submissions.
Millets,
to the
if
supervisor.
I am allowed to submit millets by the date this academic year may close.
Can't help. Can't help.
Yes, my lords,
Then
we
millets
had to
mostly in
mention for a
academic actors.
formal order of tagging.
Yeah,
It-
we'll do it.
it'll all come
all the matter together.
all the matters together.
Millets,
All
if
matter.
possible, consider millets any other shorter date because the admissions will be over for the academic.
21st.
March, my lord.
Ah.
That's a Sunday, my lord.
29.
We'll be here.
That's
24th. 24th. 24th.
24th.
You can come on Saturday.
Millets. Could it be any shorter millets?
It is a matter, my
Whether
lord.
the
Kindly
issue
have it in
could be
February,
Give
my
me
lords.
the list of those advocates for whom the dates are fixed. You can negotiate with them.
And
If your lordship
by
will
then,
allow
millets, the admissions may be over.
All right.
my lords, February some date, my lords.
It's February is over, madam.
Almost, my lords, but if your lordship would take it, my lords.
We'll have
Soon after vacation, millets.
Whatever date.
Soon after vacation.
It's not possible, sir. We have
No,
seen
they
that.
have- then we can't.
It's already fixed and fixed those
There's no
dates.
point in doing this for
That's
3,000.
not possible.
3,000 intervention.
We have given it before the vacations, right?
Yeah.
24th, right?
Great.
Grateful.
Grateful, my lords.
For formal notice, I'm presuming.
Already done.
Wait.
Item 56 clearly. But इसको इतना लोग
Because I filed my counter on two aspects, my lords. One is with respect to the medical, what they had filed on interim bail, but it's not on record, my lords. That is why I'm carrying the hard copies. I'm carrying the hard copies, my lord. What is very interesting in this, my lords?
55.
56, my lords.
56. Yes.
But what is very interesting is, my lords, they apply for an interim bail on the grounds of wife's medical concern, my lords, who goes and visits in August last year. If my lords may kindly see the statement given by the doctor, which is at page 6R1, my lords. It is submitted that I examined the patient in emergency, presented with pain abdomen. Patient was treated for ileocytis. After conservative management, patient was discharged and advised to consult Department of Surgery, post which patient did not turn up for follow-up. This is the only document what they are relying on medical grounds. After August, there is not even a single document on medical grounds saying